Yes. Mr. Bandyopadhyay, yes.
They are hearing combined out of time. I will paper. Find the paper. That's all. Come up. Say, after the
Give the slip.
With the lots I am mentioning, I'm praying extremely urgent matter. 36,000 teachers have been, their appointments have been cancelled after 7 years by stroke of pen, my lord. We have not been made parties. My lord, I have a leave to appeal. I have a stay application on the grounds of appeal. Kindly grant me leave, my lord. My lord, I have been told, my lord, that the two other matters have been fixed at 3 o'clock. My lord, can I, my lord, pursue, my lord, can
Give, ask you, file it, give the numbers.
yes, I will give it, my lord, and I will also argue, my lord. There are number of points are there.
Let the file come.
Yes.
See that the file comes.
My lord, yes, yes.
It will leave the number.
Deeply
Ask
obliged.
your learned junior to
No, everything I will personally take care about this matter.
so that the file comes.
Yes, I will personally.
Because we have fixed these matters.
Yes,
no
correct.
point hearing these
That's the reason.
matters separately.
The fate of 36,000 persons are there. I will take personally care.
Well, that's that is.
Yes.
Let's see the file comes. Then
My lord,
the
my lord.
file is there. Then we can take.
My lord, only request I will make, my lord, I will give the mat number.
Mr. Biswas is watching you from behind.
My lord?
Mr. Biswas is watching you from behind.
But, yes, he's with. They are also appellant.
His two matters are at 3.
They're the appellant. I will just request, my lord, the moment I will give the number of mat number, the requisition will be
for
sent.
the file.
My lord, so deeply obliged. To your judgment.
Yes, Madam Sucharita Paul.
Lordship, one restoration application, Lordship. This is the third time I'm mentioning. I'm sorry, Lordship, I could not appear in the matter. Lordship will kindly allow the matter to appear in the list. I'm deeply obliged, Lordship.
Lord, one matter, Lord, item number 227 to 231. Lord, this is in the monthly, Lord. It's a matter, Lord, concerning, Lord, the College Service Commission. Lord, what happened, Lord, due to pendency of this review application and, Lord, the application, Lord, this matter, Lord, before the learned single bench, Lord, cannot be, Lord, proceeded with. Your Lordship, kindly.
My lord, this is an appeal from an order dated 27th April. My lord, I'm praying for leave to file without certified. I'm grateful.
Well, it is only applicable. Extension of interim. Extension of interim.
Your Lordship, may I permit it for mentioning for non-prosecution.
Yes.
My lord, in this matter, originally this matter came up with your lordship challenging an order passed by Honorable Justice Shampa Sarkar. The order dated 25/2022.
My lord, I'm for the respondent. My lord, Mr. Ashwin Kumar Raut is appearing. He couldn't come today, my lord. He couldn't come today, my lord. Mr. Ashwin Kumar Raut.
My lord, the interim order here in this case was till 30th April. We mentioned this matter accordingly on 27th April and lordship had been pleased to allow our mentioning. But for reasons beyond our control, the matter did not appear in the list. Subsequently, under such circumstances, we have filed this application, my lord. And a contempt application is pending, my lord. Originally, the matter was fixed to be heard on 3rd April. But the matter did not make it to the list, my lord.
We fixed a date and yes, you are appearing for?
My lord, I am appearing for Bengal chemicals.
For the
appellants.
who you are appearing for?
Yes. His with
Same site. The interim order is expired long back in April.
My lord, we already mentioned.
When did you mention first?
I mentioned on 27th April, my lord, and your lordship.
End of April.
It expired on 30th April. And prior to expiry, my lord, I already mentioned the matter and your lordship had been pleased to allow the mentioning, my lord.
Correct. So
The matter did not make it to the list, my lord. And subsequently, under such compelling circumstances, we have filed this application.
when did you file the application?
My lord, the application had been
Yes.
filed post expiry. My lord, the application had been filed on,
What is the application number?
well, the application number is CAN 2 of 2029. CAN 1.
You prayed for a fresh interim order.
I'm praying for a fresh interim order, my lord.
And kindly fix
In this
it.
matter, my lord, I am led by Mr. Joydeep Kaur, but for some reason, Mr. Kaur is not available today.
Fix the date.
When will Mr. Raut come?
My lord,
Loudly,
come-
please, on the microphone.
my lord, he will come tomorrow, my lord.
Tomorrow.
He told me that to make this not today only.
We'll take it up tomorrow.
My lord.
Extension of interim.
My lord.
No, just tomorrow, extension
My
of.
lord, kindly make it after vacation, my lord.
No.
My lord,
Order record kore.
Record.
Parties this / are represented in the order of their name / names as printed above in the cost line. Full stop para. The appellants are represented. Full stop para. The appellants submit that the interim order as granted as granted earlier and last extended by this court by order dated 1st of March 2023, expired in the end of April 2023.
First it, the second.
Full stop. The appellants further submit that full stop. The appellants further point out that the matter was mentioned before the Honorable Court for extension of the interim order prior to its expiry in April 2023. Full stop. However, the business of the court did not permit the matter to be taken up, and hence the appellants have filed CAN 2 of 2022, which is for reimposition of the interim order as earlier granted on the same terms. Full stop. On behalf of the respondent / writ petitioner, you may give your name. Mrs. So-and-so, learned advocate appears. Full stop. An opportunity is sought by the respondent / writ petitioner to address this court on the next day through learned senior counsel. Full stop. It is further submitted on behalf of the respondent / writ petitioner that the matter be now taken up after the reopening of the court at the end of the long summer break, 2023. Full stop para. This court is not persuaded to wait for the respondent / writ petitioner to wait for the respondent right any further, only for the purpose of only for the purpose of continuing the interim order which was granted and continued earlier. Full stop. This court must also point out that the interim order was granted and continued earlier always in presence of learned counsel for the respondent / writ petitioner. Full stop. Accordingly, the interim order stands extended till the end of July 2023 or until further orders, whichever is earlier. Full stop. Para. Let the matter appear next under the, what heading was it appearing?
My lord, it should come under hearing because the,
Have you served CAN 2 on them?
I have.
Where is your affidavit of service?
The affidavit of service, I'm undertaking, I'll just submit, my lord. My clerk is actually just affirming the affidavit, my lord.
Or you file it under,
My lord,
otherwise the order will
I'll
never
file
be
it.
signed.
Within the course of the day, man. I'll file.
Full stop. The appellant, full stop, let the matter appear under the heading Application Group
6.
Application Group 6 in the monthly combined list of June 2023. What July na kore June kore dao. Let the interim order stand extended till the end of June 2023 or until further orders, whichever is earlier.
June, 8th of June, there will be vacation, my lord.
Vacation will close by the 4th of June, so you come back. Application Group 6 in the monthly combined list of June. Can 2 of 2022 stands, 2023 stands accordingly disposed of.
My lord, may I just sought for accommodation till 10th of June? Because otherwise I'll not even be in a position to mention this matter for further extension because it will expire in June.
Let the matter appear under the heading Application Group 6 beginning the week beginning 12th of June 2023.
I'm good.
I'm grateful, my lord.
You wanted after vacation, it is after vacation.
I'm grateful, my lord.
Interim order is till the end of June 2023 or until further orders, whichever is earlier. If you want to make a prayer, make a clear prayer. You wanted not today, we were granting you not today. You said tomorrow, we said tomorrow. Suddenly, why do you say after vacation?
My lord, he's not well, so maybe he couldn't come tomorrow.
So that maybe you should have thought about before outside the door of the court. But when you're addressing the court, be firm in what you want to say.
I will do that.
Don't spoil the image of the advocate and the client.
I'm grateful.
Court has to always take you seriously. What happened?
I lost my mother.
When?
1st of May.
Condolences.
Yes.
We offer our condolences. We never nickel. Yes.
My lord, this matter was, my learned friend is today not there, but Lordship may kindly remember this matter was heard on 21st of April after hearing, though in the order it is not recorded, I have seen, but your Lordship expressed that certain notifications regarding what kinds of grants can be provided to be brought by the state. So
That school.
yes, that school. So in fact, today, if that is brought, I would have otherwise thought that if the matter can be taken.
Lordship, in this matter, Koeli Bhattacharya is appearing on behalf of the West Bengal Board of Secondary.
Raise the microphone to you.
Lordship, in this matter, Koeli Bhattacharya is appearing on behalf of the Secondary Board. Lordship, she couldn't come to court for her personal difficulty. Lordship, kindly.
We cannot hear you. What has happened?
A personal difficulty as
Personal difficulty, Lordship.
Yes. On the microphone, please.
Lordship, she could not come to court because of her personal difficulty, Lordship. Lordship,
Yes.
kindly take it up tomorrow or day after tomorrow.
the only thing is that if this instead of tomorrow or the day after,
After it will be after vacation.
Right.
Mentioned matters in the combined monthly list of June. It will retain its position. Ashun. Shahib Kachar. For appearance to note.
Father, you participated today?
appear করেছে।
What a brother.
The learned counsel appearing on Mr. Thorn, learned Mr. Thorn, the senior counsel appears on behalf of the appellants. While this non-renewable representing Ms. Koheli Bhattacharya for the West Bengal Board of Secondary Education. In a non-renewable representing Ms. Koheli Bhattacharya, who is appearing in this instance is for the West Bengal Board of Secondary Education. In 6 time on her ground. Personal ground. Full stop. Let the matter appear. Matter will appear in the monthly combined list of June under the heading mentioned matters.
Lordship.
And state is to be informed.
We have used the expression that they intend to address this court on the next day. No accommodation.
Yes. Then, my lord, it's my appeal, my lord. Your lordship remembers that matter where was ossification test has been, the SSKM hospital has been directed to do the ossification test in place of the.
Mr. Partha Ghosh.
Yes, my lord, what happened, my lord? Ossification test has not yet been done, my lord. The date is scheduled on 18th of this month. If your lordship sees your lordship's asked order of 25th of April 2023.
It is scheduled on 18th of May at 12 noon.
Yes, my lord.
So let the matter appear in the monthly.
Yes, my lord. Let it appear after vacation, my lord, any day. Well, my only prayer is, my lord, kindly see if they do not proceed with this contempt. If the contempt comes, limited protection, nothing else. But
The council appearing on behalf of the appellant submits that the ossification test has not yet been conducted. But it is scheduled to be conducted on the 18th of May at 12 noon. Full stop. A report has been sent by the a report has been sent by the medical. A report has been sent has been furnished by the medical superintendent cum vice principal at SSKM Hospital, Kolkata.
May I take your lordship's leave, madam? One of my matters is taken on 25th.
through the learned registrar general. Full stop. As per the earlier order dated 25th of April 2023, it was directed to hold the ossification test of the writ petitioner, and from the report which has been furnished today, which we kept with the record, reveals that the said ossification test is scheduled to be held on the 18th of May 2023 at 12 noon at the chamber of Dr. Bishwanath Soren. এটা এই কারণে বলে দিচ্ছি, কারণ হচ্ছে তাহলে দুপক্ষেরও জানা থাকবে, ঠিক আছে? At the chamber of Dr. Bishwanath Soren, second floor of FSM building, IPGMER, এখানটা দেওয়া রয়েছে, ঠিক আছে? আইটেম নাম্বার 1 considering the fact that the ossification test is scheduled to be held on 18th of May, let the matter appear in the combined monthly list of June under the heading mentioned matters. Stop. The medical superintendent cum vice principal, SSKM Hospital, Kolkata, is directed to comply with the order dated 25th April, comply with the earlier order dated 25th April 2023, and to furnish the ossification report through the Registrar General within the next date. Period. The matter will appear in the monthly combined list of June 2023 after the ossification test is conducted on 18th of May.
Okay.
Has Mr. Ghosh come to court?
Yes, Your
Give his
Lordship.
name.
I will.
If he has come to court, give his
Yes, he
name.
has come to court, Your Lordship.
Oh.
এটা প্রতি অ্যাপেলেট ম্যাটার, মানে the last 8, the last occasion my lord the matter was heard in presence of the learned counsel for the state was the appeal last occasion Mr. Choidali Bhattacharya and Mr. Kapas Kumar Kartik Chandra Kapas, and matter was fixed, my lord. Matter was heard, my lord. The only 2 questions involved in the matter, my lord. My compensation appointment refused by the authority, district inspector of school, only on the grounds the family of the deceased are, my lord,
Are you appearing in this matter?
Senior Advocate Choitali Bhattacharya is appearing for the state, but hearing matter is going on the courtroom number 18.
So you represent in the meantime. Let her come.
Yes,
Let them start. You represent them in the meantime.
I am highly
Grateful,
grateful, my lord.
grateful, my lord. My lord, my lord, refused by compassionate appointment only on the ground family, my lord, the not in the hardship. He has paying pensionary benefits and terminal benefits and counting the pensionary and terminal benefits taken for computation of family income, and my refused, my lord. Then I filed writ petition, my lord. The writ petition, my lord, the rejected only on the, my lord, relying on subsequent judgment by the learned trial of this court, my lord, Shashi Kumar. But this judgment also referred before your lordship. Kindly see the judgment. I am only the question, my lord, the Shashi Kumar judgment, my lord, the rejected the applicants, my lord, my apex rejected the claim only on the two grounds: delay of 7 years application. The application made by the applicant therein, my lord, after 7 years, after the decease of the employee, and my lord, he comes before the court. I was already referred, my lord, kindly see, got it, my lord. In relying the recent judgments, my lord, 2019 in Shashi Kumar, Himachal Pradesh, my lord, my application, writ petition rejected by this learned court. My lord, submission before your lordship, my lord, kindly see the judgment, paragraph number 39, 40 and 41. My lord, the court, apex court consider and rejected the claim only on the grounds of delay. When the application made for compassionate appointment, there are lapse of 7 years. And in the meantime, before making claim, before submitting his claim, pension benefit and terminal benefit has also been granted by the authority. That's why, my lord, the apex court consider the aspect, the delay and lapses of the applicant by making an application after 7 years, and in the meantime, the benefit of pensionary benefit and terminal benefit has been, my lord, the has been, my lord, the disease employee, my lord, the enjoying. That's why, my lord, there is no.
On which ground your claim for was denied? On which ground your claim was denied?
Claim was denied by the district inspector of school.
On which ground?
Only the ground, the family, my lord, family, only the ground, the family of the deceased, my lord, earn pensionary benefit and terminal benefit, and the family, my lord, the enjoying the money
that is higher than
the group D,
higher than the gross salary.
Group D employee salary. That's why we are rejected. I challenges this impugned order before this court, my lord. The writ court, my lord, the I have referred judgment, several judgment, Prakash Bharma and such, my lord, Canara Bank, when this court and others court also consider the claim on the basis of the judgment, with the judgment says.
Lord, be seated. Let us go through the impugned order. Be seated. Let us go through the impugned.
Kindly see the impugned.
এনেছেন এটা ডিস্টিংগুইশ করছেন আপনি সার্কুলারটা 97 সার্কুলারটা
13 এসেছি 97 সাল 2009 এর তো 2013 তে একটা হয়েছে
না
13 তে একটা হয়েছে Yes, Lord Counsel. Now you can proceed. My lord, only the rejected the subsequent judgment Shashi Kumar, my lord, and the all other judgment by I refer before your lordships. The in view of this, my lord, the Shashi Kumar judgment, my judgment, the refer the judgment Bharma, Govind Bharma, and such and such, my lord, they ignore. Right. My lord, my condition is that my lord, this Shashi Kumar judgment is not applicable in my case. My lord, kindly this is paragraph number 39 of Shashi Kumar judgment. Kindly the paragraph number 39. Page, my lord, page 12. My lord,
Stay application
my lord,
of
this
the
Shashi
stay
Kumar judgment.
of the stay application.
No, my lord, I have referred before your lordship earlier location, this Shashi Kumar. Yes, yes. My lord, kindly state of Himachal Pradesh versus Shashi Kumar. My lord, the paragraph number 13 only, my lord. I
Paragraph number 39.
39, paragraph 39 of the judgment, Apex Court judgment, page 12. Lordship got it. Insofar as the individual facts pertaining to the respondent are concerned, it has emerged from the record that the writ petition before the High Court was instituted on 11 May 2015. The application for compulsory appointment was submitted on 8 May 2007. And on 15 January 2008, the Additional Secretary had required that the amount realized by way of pension be included in the income statement of the family. The respondent waited thereafter for a period of in excess of 7 years to move a petition under Article 226 of the Constitution. In Umesh Kumar Nagpal, Supra, this court has emphasized that the basis of a scheme of compulsory appointment lies in the need of providing immediate assistance to the family of the deceased employee. This sense immediacy is evidently lost by the delay on the part of the dependent in seeking compulsory appointment. And my lord, thereafter, my lord, we are not impressed with the submission that delay should not be taken into account, since paragraph number 8 of the scheme contemplated that in a situation where all the dependent children of the deceased employee have yet to attain the age of majority, the time limit for submission of an application is extended until the first of the children attains the age of 21 years. A case where each of the children is a minor falls in a different class altogether. This cannot be equated with a situation where a dependent of a deceased employee who was a major on the date of death fails to submit an application within a reasonable period of time from the death of employee. This aspect delays such and such by the judgment. We are no reason to purpose in now directing the state to reconsider its decision in the case of the respondent, which would only result in another round of litigation. In our view, the respondent is debarred from seeking in compulsory appointment by the delay as well as by the lapse of time which has taken place. Well, in this aspect, on the delay ground, well, kindly my submission before your lordships. The applicant well, make an application for compulsory appointment after 7 years. After 7 years. When before making an application, authority already disbursed the pensionary benefit and terminal benefit. My case, my lord, in hand on your lordships, my case, I have applied immediately after the death in the year 2012. The employee died, my mother died in 2012, January, and July 2012, I make an application. Since then, application is pending. And the pensionary benefit, which was, my lord, disbursed to the my father, in favor of my father, in the year 2015. I am, my lord, submitting before your lordship the pensionary documents. My lord, kindly see my pension was disbursed on 2015. 2015, when application still pending. My lord, the important factor here is when the claimant made his application for compulsory appointment after death of the deceased employee. The question decided by the Apex Court 7 years latches. And before the application, also the family also disbursed the pensionary benefit. My case is otherwise, my lord. My case, my lord, my pensionary benefit disbursed 2015. My employee died by 2012. I make an application immediately on 2012. My application still pending. My lord, this aspect, the Apex Shashi Kumar judgment is not applicable to my case. And this case, my lord, only the ground delay and latches, and the benefit also by enjoying by the deceased family. That's why, my lord, the claim of compensation apparently refused by the Shashi Kumar. My case is not applicable in the instant case, which I have submitting before your lordship. Kindly see the pension documents I have submitted before your lordship. My father disbursed pensionary benefit in the year 2015 in view of memorandum issued 2014. I am submitting before your lordship. And this aspect, my lord, kindly I am submitting, draw your attention, your lordship. Kindly see our High Court judgment. My lord, the question of application time of making application is a question, and it has been decided by this court, our court also. My lord, kindly see the judgment.
Lord Counsel, your prayer,
Unreported judgment, my lord.
your prayer for appointment,
My lord.
your prayer for appointment
Appointment 2012 July
on compensatory ground has been rejected on the ground
2000 on the ground of, my lord, the family also disbursing payments already.
total earning of the family is higher than the gross
Higher than the group D staff.
gross
group
salary
D
of the
staff.
group D staff.
My lord. In the year 2015,
Yes.
my application was the 2012. The Shashi Kumar judgment application, where after 7 years lapse, Shashi Kumar judgment, the applicant applied for compensation appointment after 7 years. On this aspect, Apex Court might refuse the claim because in the meantime, the deceased family also enjoying the pensionary benefit. But I have made application when the pensionary benefit has not been disbursed, and pensionary benefit disbursed after 4 years when my application is pending, my lord. That's why I am saying before your submitting before your lordship, Shashi Kumar judgment refused the claim of compensation appointment only on the ground of delay of 7 years, which is not at all applicable in my case.
When your father started to receive the family pension,
2014 memorandum, and from 15 he disbursing the pensionary benefit.
and in the meantime you have married.
Yes, my lord. Yes, I am
Change
coming
of
to before your lordship in the marriage. Subsequently, the state of West Bengal, my lord, modified the memorandum.
You are
The
relying
married daughter also eligible,
Lord
and my lord, our court, my lord, the
Lord
special
Counsel, you
bench.
are relying upon the fact that your father started to receive the family pension after 4 years from the expiry of your mother.
Expiry of
This you are claiming on your behalf.
Yeah.
The advantage.
My application, and when my application is still pending.
Yes. But on the other hand, you have been married.
Yes, I have married, my lord. I have subsequently married, my lord, 2018. 2018, I have, my lord, stated in my writ application also. I have stated, my lord, the marriage is question, the other question. This court, my lord, our High Court, the larger bench presided over the Honorable Chief Justice of our High Court, decided the issue, my lord, in 2 occasions and passed judgment. My lord, referring the judgment, married daughter, when the claim is pending, the claimant in the meantime got her marriage. My lord, he is eligible to by the compensation appointment. My lord, kindly see the judgment, my lord, our High Court, larger bench. The state of West Bengal others versus Purnima Das. My lord, Honorable Justice, Chief Justice Nishita Matre, Dipankar Datta, Tapabrata Chakraborty, my lord, decided the matter. My lord, kindly see paragraph number 113 and 119. Page number 26 of the judgment. 113, my lord, subsequently the offending provision in the notification such and such, my lord, that is the adjective unmarried.
Paragraph number?
Before daughter.
Paragraph number?
Paragraph 113. 113. Page 26, my lord. My lord, the adjective.
The authority which you have provided contains
My lord, the judgment.
69 paragraphs.
Judgment
And
Purnima Das.
69 paragraphs and consists of 13 pages.
Oh. Oh. তো পূর্ণিমা দাসটা চলে এসছে এটা দে এটা দিয়েছি I'm sorry, madam. So sorry, madam. Sorry. Not this. Madam, this is the another judgment. Madam, kindly the paragraph 50 on this judgment. Paragraph 50. I'm sorry. Great. Sorry. Paragraph 50.
Five zero.
50, madam. 50, madam, page number 9 of the judgment. Having, kindly say, Lordship, having regard to the scheme of compensation appointment as envisaged in chapter such and such, we have no doubt in our mind and accordingly hold that an unmarried daughter as appearing in clause such and such would not only include daughter who has never been married, but also a daughter who was once married, but her marriage has been dissolved by decree of divorce, and she remains not married on the date of death of her father, mother, the worker. We find no good reason as to why by putting a strained construction on the words unmarried daughters, a divorced daughter should be held to have been excluded and a person malignable for consideration. And kindly see the page 58. 58. The decision of the division bench Eastern Coalfields Limited cannot be received as one rendered on a once by ECL, paragraph 3 to 5 of the said decision, as we have noted above, were quoted by the learned judge in the said judgment. After referring to the law and constitutionality of a term or of a provision has to be considered only where it is inappropriate. It was held upon by the division bench the fact that it is not necessary to decide that aspect at all, since clearly the status of the daughter of the writ petitioner was that of an unmarried daughter. On the day when the writ petitioner claimed employment of her, the division bench then proceeded to record the submission.
What interim order are you seeking?
My lord?
What interim order are you seeking?
My lord, interim order, I have
interim order.
Interim order, actually, my lord, the application made, my lord, the analogous to my lord, the memorandum and application, my lord, can be heard. My claim, my lord, also pending, my lord, since 2012. There is no needed interim order, my lord. Kindly can be heard, my lord, along with the memorandum of application, my lord. This is my submission. Since, my lord, my claim compensation appointment, my lord, pending since 2012, my lord. And in this, I am submitting before your lordship, if permissible, if the
affidavit's been exchanged,
my lord,
Yes, my lord.
counsel, had the affidavits been exchanged?
No, my lord, this is the first time it is being moved in the appeal court, my lord. And my lord, there is the rule, and where, my lord, it has been culminated that what are the conditions which will be considered as financial hardship. And as per that conditions, when there are the enumerated conditions are there, so my lord, compassionate appointment cannot be, my lord, given beyond the scheme or beyond the rule itself. It is not even the scheme, it is the rule. School Service Commission appointment, selection and appointment of persons, teachers rule, that is 2009. And there, my lord, the rule 20, 21 and my lord, schedule 5, it was categorically it has been culminated, my lord. And according to that, my lord, Shoshi Kumar has come for that reason. It was argued by my learned friend that pension cannot be considered. That is in the Govind Verma, that pension cannot be considered as the income. For that reason, my lord, in Shoshi Kumar, it has been categorically held that whenever the scheme has formulated that this income will be considered, then it has to be considered. And beyond that, compassionate appointment may not be given. That is the, my lord, Shashi Kumar, my lord, section 20 and paragraph 20.
60% of the family pension.
Yes. And my lord, 20, in paragraph 20 of Shashi Kumar, Govind Verma has been distinguished. And he was relying upon that Govind Verma case. That is, my lord, schedule 5 of that rule. Rule এর নামটা কি যেন? একটা বিরাট বড় নাম। 2009 Yes, my lord. Rule is, my lord, name West Bengal School Service Commission selection of persons for appointment to the post of non-teaching staff and rules. My lord, here, my lord, that is teacher, primary teacher and teacher all were included, and schedule 5. If your lordship would be pleased, I may file affidavit or whatever as your lordship would be pleased. Within, my lord, 2 or 3 weeks after vacation. Or 2 weeks after vacation, my lord. 3 weeks will be, my lord, long.
Reply.
Reply, my lord, within 1 week. My lord, the time is a factor. Consider our delivery money. Hello, opposition.
And my lord, even
এটা তো মানে before passing judgment, I wrote the 2013 scheme of the government modified by the earlier judgment.
Let the affidavit in opposition come, be filed within 3 weeks after the vacation.
My lord, 2 weeks, my lord, 2 weeks. My lord, the claim is 2012.
The matter will appear in the monthly combined list of July.
as your lordship.
Under the heading,
any date, my lord, supplementary list. My accommodated, my lord, my humble submission before your lordship. This is the compensation appointment, and considering the urgency, gravity of the case, my lord, fix the matter any day, my lord, lordship's convenience.
The matter will appear under the heading mentioned matters.
Mention matters.
So you are assured to be heard of.
Yes.
Parties appear accordingly as mentioned in the first title. The learned counsel appearing on behalf of the applicant
No, মামলা হয়ে যাক তারপরে নিয়ে যাক। এটা আপনার ঠিক।
submits that
এটাও
he is entitled to appointment. He is entitled to appointment on compensatory ground.
করতে চাই যে আপনি আফটার ভ্যাকেশন রেখে ওইটা উনি নিয়ে করার যদি সেটা যাচ্ছে একটা দাবি।
আপনি বলেন। আপনি না বললে হবে না। আপনি তো অপোজিশন করবেন। আপনি ব্যাপার।
The learned counsel appearing on behalf of
ওই ইনকাম গুলো তো বলতে হবে সেই জন্য।
state. Yes, Bhattacharya.
My lord,
Submits that.
as my lord requested by my friend, if your lordship would be pleased, my lord, as it is from the rule, if my lord any day taking the rule into consideration without filing affidavit, if the matter may be taken up, if subject to consideration of your lordship.
Let the affidavits be filed.
As your lordship. না বলছে affidavit is to be filed.
Submits that that the appellant is not entitled to appointment on compensatory ground. Full stop. Paragraph on compensatory ground. That the appellant is not entitled to appointment on compensatory ground. Full stop. As paragraph, as affidavits have not been exchanged earlier, let the affidavit in opposition be filed within 3 weeks. Within 2 weeks. 2 weeks after the summer vacation, and reply. Affidavit and reply is filed within 1 week. Thereafter, let the matter appear under the heading mentioned matters in the monthly combined list of July. Two weeks for filing the opposition. 1 week. 1 week thereafter for filing reply. The matter will appear in the monthly combined list of July under the heading mentioned matters.
I am grateful to your lordship.
Grateful. I'm grateful.
Lordship, in this matter, Koili Bhattacharya is appearing on behalf of the secondary board. Lordship, kindly, she could not come to court for her personal difficulty. Lordship, kindly take it up tomorrow or after vacation.
After vacation, it's a interim order.
Well, the proceedings thought to be initiated by the board is being stalled by just filing the application and keeping it pending. Although I'm not the applicant, I had it listed.
It will be in the list in the heading mentioned matters after vacation. Retaining his position after vacation.
Lordship, yesterday I have filed.
Wakalatam has been filed.
Yes, Lordship.
Let the filing number be provided.
1 of 2023.
Biolo.
Date the calculator file.
Let the number be provided. So this Phoni Kumari
Lordship,
and this appellant
yes,
are on the same footing.
my lord,
So the similar order can be passed.
yes. My lord, only my lord, in Soni Kumari there was a direction for filing of affidavits, my lord, that should remain, bus. Nothing else.
That should
Remain. In the last may kindly consider last page of the order of Soni Kumari.
Soni Kumari was second paragraph.
Student lordship. That was
On the microphone, on the microphone.
in this case, appellant is civil engineering student and Soni Kumari was BE engineering student.
Party parties are represented in the order of their names as printed above the first title. The issue before this court is as per the learned counsel appearing. No, what a second paragraph. No, the issue about this. The learned counsel appearing on behalf of the appellant submits that Wakalatnama has been filed. Here's the number 1 of 2020 has been filed on 15th of May 2023. That is yesterday. Hearing the number 1 of 2023. Full stop. The issue paragraph. The issue before this court is the grievance of the appellant, namely Orijit Dev. Not being allowed to continue as a fifth, continue under the fifth semester, continue the fifth semester, continue the fifth semester in the college in issue. ওটা থাকবে the learned counsels appearing on behalf of the appellant and for the university submits that the instant appellant, namely Orijit Dev, is similarly circumstanced as that of Soni Kumari, in respect of whom an order has been passed by this court in Mat 444 of 2023 with interim application, with connected application dated 18/4/2023. Full stop. Paragraph. The only difference between these two cases is that Soni Kumari was a student of Learned Counsel, Soni Kumari was a student of? Soni Kumari was a student of?
B engineering.
BE Engineering. BE Engineering. While this instant appellant
Appellant is civil engineering.
Civil engineering
Civil.
is studying civil engineering. Civil engineering. Full stop. All the facts, paragraph, all the facts remaining similar. The order mentioned above, passed in MAT 444 of 2023, will apply in this instant appeal. Paragraph. Let affidavit in opposition be filed within a period of 4 weeks from this date. Reply, if any, be filed within 3 weeks thereafter. Within 3 weeks thereafter. That paragraph. It is to be made clear paragraph to B, it is made clear that this order is being passed in the particular facts of this case. It is being made clear that this order, it is being made clear. It is made clear. It is made clear that this order is being passed in the particular facts of this case. Remaining parts, remaining order, same. So both MAT 444 of 2023 and this one being similar, the order passed in 444 of 2023 is applicable in this list also, and you are given the liberty to file affidavit in opposition within 4 weeks.
My lord.
After the vacation. Sorry. Yes, 4 weeks after the vacation.
Lordship.
And reply within 3 weeks thereafter.
Lordship. Grateful.
That's a plain copy of the order. Plain copy of the order, Lordship. So that the
from the server copy will.
Server plain copy to take
server copy. যেটা আমার লেখাটা আমার কাছে পরে আবার
Madam, for the appellant.
Before my learned friend, my lord, start, my lord, before the honorable single judge, my lord, I appear on behalf of the state. My learned friend, my lord, serve a copy of the stay application, my lord, upon me. My lord, since, my lord, that was not, my lord, through the learned, my lord, GP, my lord, I return back the copy to my learned friend and requested to serve the copy.
My lord, I'll serve again, my lord. Let it be, my lord, regularized, my lord. He is not the, my lord, answering respondent. My learned friend is appearing for the answering respondent. Copy নই বা কেন আর ফেরতই বা দাও কেন? My lord, may I, my lord, tell the, my lord, the facts, my lord, in nutshell.
You appear for the state.
I appear for the state before the Honorable Single Judge.
Yes,
The learned friend, after filing this appeal,
yes,
serve a copy of the memo and the connected application upon me.
yes,
I was not engaged by the copy was not served upon the learned government pleader.
yes.
So that was not the form there copy not be served upon me. I return back the copy to my learned friend and requested to serve the upon the office of the learned government pleader so that the
Very well. You appear today. He will serve a copy on you. Your appearance will be regularized. So that takes care of that part. Mr. Pinaki Bhattacharya is for the.
I am appearing on behalf of the District Primary School Council, North Chowdhury, District number 4.
What is the matter about?
I tell you,
Yes, you may take your seat. We'll regularize you.
2009 recruitment process. Ultimately, order of this honorable court, the panel was published in the year 2021. Appointments were made. The petitioner before your lordship, the appellant, was a PH category candidate. After the result published, the panel published, he found his name was not featured in the panel. He made a RTI application under section 6 to know his the score. They replied that the score of the petitioner. There he found his score is better than the much higher than the last panel candidate of the particular category PH. Then the petition was moved. Firstly there was a direction for filing a report. They filed a report annexing one document that my name was sent to the Commissioner of School Education for approval. Thereafter, when the petition was came up for hearing before the learned single judge, your lordship kindly produce the order of the learned single judge. Page 84. The 5-line order, your lordship kindly and may I read my lord? The last but the last line, last but the first line, same does not disclose the nature of disability. I have annexed the disability certificate at page 51. Your lordship kindly come to page 51, your lordship. Two things. Already my name has been sent to the Commissioner of School Education by the Council for approval. Your lordship, I am drawing to your lordship's kind attention at serial number 1, column 1. Nature of disability. Your lordship will find in handwriting, motor weakness, both the limb, both lower limbs. This is the nature of disability. Both the lower limbs are weak. He is a handicap. 45%. The next paragraph, paragraph 3, your lordship will find 45%. This is the case I am entitled to get appointment. In the meantime, I do not know my learned friend can apprise your lordship whether my name was approved by the Commissioner of School Education or not. But the similar situated candidates were all given appointments.
Where is the report?
Your lordship kindly come to
Page 72.
Page 72. Page 70. Page 70, page 72 and page 74 is important. And page 74, they have admitted that my name was the approval was sent
as PH category candidate. Your lordship will find, my lord, at page 75, the true copy of the approval, my lord, the letter of the council.
So DPSC has sent your name.
Yes.
And now the state has to answer.
My lord, they are the approving authority. They can also apprise your lordship whether the, my lord, approval has come or not, my lord.
First at all, my lord, at the time of verification, my lord, petitioner does not produce the disability certificate. That's why, my lord, treated as a general category.
Where have you said that?
My lord, page 72, paragraph number 8. That in compliance with the order dated such and such of the Honorable Justice Sujit Gangota in the aforesaid matter, the Chairman District Primary School Council North Chobis Pargana issued a memo number such and such to the Commission of School Education for approval of Sapon Kumar Das for appointment as a primary teacher. In the said memo stating entirely that now in compliance with the order dated such and such of the Honorable Justice Sujit Gangota in the aforesaid matter, if Sapon Kumar Das is treated as PH candidate, he is much entitled to get a place in the panel of qualified candidate of teacher recruitment examination 2009. North Chobis Pargana, District Primary School Council.
Where was he?
Consequently eligible for appointment as primary teacher.
Yes. When was he required to furnish the disability certificate? At what point?
At the time of scrutiny verification.
At the time of verification, my lord.
At the time of verification.
Verification does not produce the documents.
Disability certificate.
Thereafter he produce.
Then he comes later with the disability certificate.
Yes, ma'am.
Where is
My
that?
case is that I have produced. At the time, my case, but I have produced at the time of, my lord, your lordship kindly assume, my lord, any prudent man or, my lord, any person, my lord, having the disability certificate, I know I will get the benefit
What
of
was
the disability.
what was the application? Mr. Baisho, where is
But
his
lordship, kindly
application?
see the lordship's order, trial court order, lordship.
We have seen that.
Trial court order, lordship, the certificate of the disability does not generate any confidence in the mind of the court as to the same date, does not disclose the nature of the disability.
That is wrong.
Not mentioned. I am only praying, lordship.
The disability certificate, we are with great respect not agreeing with the trial court's final order. His disability is there, 45% that is there. Now, if he has not produced it before you at the time of verification, then possibly it's difficult to see how he can build up a case later.
No.
Let us see what did he do when the verification, when he submitted his application, what did he do? What did he write? Where is his original application? Do you have a record of his original application? You see whether he has written general category disability.
My lord, kindly come to page 53. This is, my lord, admit card. The admit card is, my lord, prior to everything, my lord.
But I am only suggest before their lordship.
No, he has to be, if you have no fault. You have no fault if he has not produced it when he was required to.
My lordship point one.
Therefore, we want to see whether he produced it at the inception. Where is the admit card?
Page 53, my lord. Your lordship will find at the bottom left-hand side that I am PH category candidate.
Now, what about the verification part, Mr. Bush? You can take
Verification,
instructions.
lordship, on the date of verification, lordship, he did not produce any of the document, lordship. That's it, my.
Where do we get that?
Here, lordship, PH lordship, when the lordship, he filled up the form, on the basis of the form, admit card has been issued. On the, not verification or any, after lordship filled up the form, admit card was issued. When the verification was made, on date the verification, he did not produce any certificate of PH.
He had to physically appear for the verification.
Lordship.
So if he has a motor neuron disease in his lower limbs, it will quickly be found out. Now let us see what is the document available that he appeared at the verification and did not produce. Where is that part? How is that part? Where is the? Could you consult the record and tell us something?
Lordship, I am produced the record, lordship.
My lord, this admit card showing that admit card issued 2012. My lord, my disability certificate 2010.
We know you have a disability. We have no problem with that. Your disability, we are not contesting. Nobody is contesting that.
No, Lord, I am contesting, lordship. But he did, lordship, as for lordship, let the lordship second medical court, medical board examine the lordship petitioner. He is a genuine or not.
Well, one competent authority,
Yeah,
three
but
member
Lordship,
of the
wonderful.
whole medical board has
Tell Lordship, as per my instruction, Lordship, let the Lordship second opinion
given
given
the
by the
last
court.
certificate by 2022. Your lordship kindly
But
mala
it is
produce.
report, but I don't know where is the certificate.
My learned friend cannot mala deny
Then
the certificate
give
of
me-
the government.
Give me the certificate, Lordship. As per
Then
my
my
instruction,
instruction,
Lordship,
he is denying the certificate of the government. His own mala.
I am not denying, but Lordship, here the 2010. If the Lordship any examination is to 2020, give me that certificate.
Yes, here are now mala.
I do not know where the certificate is the 2020.
2022.
That 2020, tell Lordship, 2020, I am not Lordship dispute about the Lordship certificate.
Mr. Vaishya, even if it was 2010, this is a kind of disability which does not go away with time. So we are not with you with regard to the nature of the disability.
Lordship.
We accept the proposition that he is disabled. We also are not with the honorable single bench now that it is a disability is such that, he cannot agree with it because none of us are experts. We are, of course, not with Mr. Biswas. What did he do at the verification stage? If he did not show it, now he cannot come say and accommodate.
Malad, may I try to pursue your lordship, Malad? The verification stage is just before interview.
Yes.
Malad, if Malad, I had not produced the disability certificate. At that point of time, I was rejected. I was not allowed to participate in the interview. I was participated in the interview. I was allowed to participate in the interview. After that, when I found my name was not featured, I got the RTI reply. They, my lord, after several years, has made out a third case that I did not produce. It is very difficult for them or anybody to prove whether I filed the
Consult your record.
Lordship, I am on the verification report. Lordship, I submit before.
Consult your record. Produce the relevant portion.
Lordship,
there is a verification procedure with no affidavits are needed. Just produce the record, and only then the question of approval will come.
Lordship.
Mr. On the basis of PH, they have sent for approval. On the basis of the PH, they have sent for the approval. That is at page 74. Your lordship, kindly see the letter, their own letter. They have sent it for approval, your lordship. They are admitted in the page 75. The true copy, your lordship will find.
We still need to examine Mr. Biswas. We'll do one more examination of the verification procedure. And what happened at that time, let them see their record and they must be showing. If they have a record of what happened at the verification procedure, we...
Your lordship, kindly peruse, one thing, your lordship, kindly, they will go, check their record and come again, your lordship, before your lordship said there is no record. No, very easy to say, my lord.
If there is no record, the entire, you get the entire benefit of it.
That's the benefit.
And if there is a partial record, you also get the benefit of it.
My lord,
but the question is whether they kept a record that on verification, what did you produce before them? That if they have to show us, and not only you, but other candidates who
all
appear
other candidates
on that date.
Those who are withheld, similar like the petitioner, all are given appointment, except myself. I do not know the reason.
Why I am giving lots. So why the district primary the personal lordship petitioner?
No, but we want to see how you have handled your verification.
Lordship, I am producing it.
All are got the appointment from the single bench, except my
lordship. If the lordship education, I am lordship send a letter to the commissioner of education. If the commissioner of education approve, that I have no objection, lordship.
He will approve. He will approve only after you show us what happened. How did you tackle the verification part?
Lordship,
once you show us that, then we will ask him to approve. He is only now an approving authority. He has nothing else to do. Ashok.
Lordship,
we are giving you a date in June. Consult the record. Show it to the learned advocate for the appellant. Let him see the record. After disclosure and inspection, let it be produced. But then one firm date because this man has to see the end of the story. Party is slash bulletin. Is slash are represented in the order of their name slash names. The appellant reiterates the position. The appellant appearing through, please take your seats, appearing through Mr. Biswas, Learned Counsel, reiterates the position that he is a physically handicapped, P capital, H capital, within bracket, PH candidate, who appeared for selection. What was the selection for? Teachers.
My lord.
Selection for assistant teacher.
Assistant teacher of primary school of 2009.
We appeared for selection as an assistant teacher of primary school of primary schools. Assistant teacher for primary schools in the year 2009. The appellant submits that although he received higher marks in the selection than the last PH category candidate, he was ultimately not selected. Full stop. Para. On the basis of a Right to Information Act, capital L, 2005, query QUERY, the appellant came to learn of the fact that when the merit panel was ultimately prepared in 2021, he was treated as a general category. Full stop. Mr. Biswas points out to the position that subsequently, however, the recruiting authority being the District Primary School Council, not 24 Parganas, within bracket DPSC, bracket close, put on District Primary School Council within bracket DPSC, not 24 Parganas, had referred the appellant's case as a PH category candidate for approval by the Commissioner of School Education, West. Mr. Para, Mr. Vaishyo, an additional government pleader, appearing with Mr. Bhattacharya, and counsel for the DPSC, not 24 Parganas, takes the position that it requires to be verified whether at the verification stage, the appellant appearing as a candidate then produced his PH category certificate. Accordingly, an opportunity is sought by learned senior counsel for the DPSC to consult the original record and revert to this court with appropriate instructions. Full stop. Para. In the view of the facts stated above, the DPSC is permitted to produce the relevant extracts of the relevant original records showing the verification procedure with particular emphasis on PH category candidates. Full stop. Let copies of the original records, let the original, the respondent slash the appellant slash the writ petitioner is permitted to take inspection of the said original records upon prior notice by learned advocate for the DPSC. Full stop. Para. Let the matter appear next under the same heading, mention matters by date at a date though.
Lordship.
6th of June, you want that will be enough?
Six Lordship is no Lord. Fifth is opening the court, Lord.
Court opening.
The sixth Lordship is no cause. 8 or 9 Lords.
No letter date. We'll give you a mention matter by date.
Lordship.
You have to see the record also.
Lordship only
On the 9th of June 2023. Mention matter by date on the 9th of June 2023. Full stop. Let copies of this appeal and connected application be served on and up. Mr. Thomas Leonard, State Council. Full stop. The appointment of
the regularized Lords. The state advocate Lordship is not appointed by the government pleader. Not
we are
Lords, regularized.
The appointment of Onanamta stands regularized. Full stop. Now is not the time for you to take instructions, but be prepared with instructions. Because if the verification goes through, all that you have to do is rubber stamp the approval.
Lords.
No, I ought not to have called Malini interview unless the verification is completed.
Let us
Somehow they are misplaced. Lost the all similar like
cinema, front row, middle row, back row, ticket you have to balcony.
That has
somewhere the ticket has to be shown.
That has exactly happened, my lord. Grateful.
And not only yours, it is an illustrative. They have to show a few others. It's not yours. Original record. If you have a problem with the original record, what they show us, tell us on that day. We will then ask for the entire original record. We want an illustrative copy. That this is how you did. So you take 7 days when you took the interview. The day, few days preceding this gentleman's interview, appellant's interview, and a few days after that. And then you collate the same. When you do some physically handicapped candidate, some general candidate, some scheduled caste candidate, let the record be illustrative for not only his record. We want the general procedure.
My lord, in this matter, Mr. Subrata Ghosh is appearing for the petitioner. My lord, he could not.
This matter will never see an end.
My
The
lord,
compassionate appointment.
my lord, yesterday he had mentioned.
Mr. Ghosh had mentioned the matter yesterday.
Yes.
Mr. Sinha, you have appeared. We will record your appearance.
Only sir, whether let it be appeared mentioned matter.
Yes, yes. It should. We'll record your appearance. This matter is, we remember, is not getting over. It is not getting over, and we will give a date when it will appear on top of the list next time. And that will be in June. Where somehow this matter has been with us. And that is very interesting. And we feel particularly, and somewhere the other time is being taken from the 16th of March 2022. This matter has regularly appeared, and there has been regular pre-put time. And this man is avoiding it before court. No. We are avoiding before court a thrashing out of the issue. He has come with a prayer, but somehow he is avoiding the issue before court. We are giving him one more time. We are putting it on top as a mentioned matter after the court reopens. Ashok. He is just now keeping the bank hanging by the hook, and the court also saying, please don't touch the hook now. We cannot just be mute spectators to this. Last order we recorded, this court expects that the party shall assist this court without praying for any adjournment. But he is right. Mr. Ghosh had told us yesterday that he would not be, before vacations is impossible to attend to this matter. We want to do it immediately after vacation. After the at a deen, the clear day though. Clear day. Or at the top থাকবে এটা. Parties / are represented in the order of their names as made above in the cost item. Full stop. An opportunity is sought yet again by the appellant to address this court on the next date. Full stop. It is expected, having regard to the previous order of this court dated 24th of April 2023, that the appellant shall make appropriate arrangements to assist this court when the matter appears next. Full stop. The respondent / the State Bank of India is being regularly represented and by Mr. Sinha, learned senior counsel, who also appears today. Full stop. The respondent / bank is ready with its instructions. Full stop para. This court is not unmindful of the fact that the matter has been pending before it since the 16th of March 2022. Full stop. Accordingly, several orders appear in the order sheet. Several orders are uttered coding. Our Bimol. Array.
Ninth. June, my lord.
9th of June, Pathar at the top.
My lord, in this matter, Shiv Shankar Banerjee is appearing on behalf of the respondent Eastern Coalfields Limited. Right now, he is arguing in court number 24 before the Honorable Justice Shubha Ghosh.
Affidavit in opposition has not yet come, my lord. Almost, my lord, 6 months. More than 6 months.
File
my lord. And my lord, we have lost, my lord, the land for, my lord, expansion of coal mining activities not compensated.
When can we do the matter?
My lord, after vacation, in the meantime, I will file the affidavit in opposition, Your Lordship.
You'll file it in the meantime, after vacation.
After vacation, Your Lordship.
How long?
1 week after vacation, Your Lordship.
Mr. Banerjee, if that is the position, then 1 week, then we put the matter back as mentioned matter.
If my lords kindly, my lord, make, my lord, these deductions peremptory this time, my lord.
Yes, the opposition is to be peremptory.
Great.
Much appreciated.
Ashun. 1 week, give them time to file opposition paper. Share with us.
No. Party. Um, Affidavit in opposition. As affidavits have not been exchanged earlier, let affidavit in opposition be filed within 1 week after the summer vacation, and affidavit in reply be filed within 1 week thereafter. Date Eolo, date after then 14 June. No, 14 June হচ্ছে না. Next week. The week thereafter. 19-20-21 এরকম, কারণ 1 week 2 week পেরিয়ে গেল, তারপরে 19 তারিখের পরে 19-20-21 জুন। affidavit in opposition
1
Within
week after vacation.
1 week after vacation, reply 1 week thereafter, and the matter will appear on 19th. 19th, 21st of June.
March.
Under the heading mentioned matters.
And my lord has kindly will not made it peremptory will not this.
Mentioned.
Great. Lord, may we will not make one more humble prayer.
Uh,
Would it be my lord's kind pleasure, my lord, to make this matter part hard? My lord said hard, my lord.
Peremptory. Peremptory, not parted. What about Can 1 of 2022? SC registry থেকে? Yes.
Great.
Can 1 ঠিক আছে। না এসে গেছে Can 1টা এসে গেছে
In this matter for the petitioner is engaged before court for praying for a short passover.
After vacation.
Lord, to the matter, Lordship.
But it is done within today.
After vacation.
Kindly keep it after vacation. My lord. Because from tomorrow onwards, পারবো না।
Come back, will maintain his.
I'm for the state law.
seen here, verification petitioner didn't produce the.
Where is our previous order? That was also land. Where is the order? Do you have your file with you? You have your file with you. You are arguing on what basis? Where are your papers?
Max 797 2020. August first matter.
Why are you showing this order? This is an interim order.
Interim order, Your Lordship. I'm demanding the same order.
Place your case.
Lordship, Your Lordship, the impugn order is page 60, Your Lordship, in the stay application.
60.
60. Annexure P6. Shoikat Pal, Your Lordship.
Pal, Mr. Pal, please take your seat. Let us read the order. We'll come back to you. You are the writ petitioner.
No, Your Lordship,
You are what?
I'm the respondent 5 and 6.
Who are the respondent 5 and 6?
And herein I am the appellant.
That's right. But who are the respondents 5 and 6?
Respondent 5 and 6 is, Your Lordship, District Primary School Council, not 24 Pargana, and Chairman of the District Primary School Council.
So how is this order bad?
Your Lordship, at the time of verification, Your Lordship, the petitioner didn't produce.
Mr. Bhattacharya, let him continue for some time. Take your seat, please. Let him learn how to, it is for his benefit. Then you take up the matter. Yes.
Your Lordship, at the time of verification, petitioner didn't produce their original caste and tribe certificate, which I mentioned in my report in annexure P4 52.
Show us. Read that paragraph, Mr. Paul.
Your Lordship, paragraph number 7. The grievance of the petitioner has raised is not justified that the petitioner has been considered UR category candidate, though he applied for scheduled tribe exempted category candidate because at the time of the advertisement of District Primary School Council, not 24 on such and such date, he does not belong to ST category and he gets ST certificate from the competent authority on 25/8/2011, but he wrongly applied. The ST category also fails to produce any authenticated documents, certificate of exempted category at the time of verification. So he was treated general category UR candidate, and total marks obtained by the candidate is 22.39, whereas the marks of the score last impellent candidate in UR category in Bengali medium is 30.88. Paragraph number 7, Your Lordship, page number 53.
Yes. Now, where is the cutoff date, Mr. Pal? In your advertisement recruitment notice, where is the cutoff date?
Your Lordship, Lordship, the cutoff date is 12/6/2010. It will be in Annex 13, page number 13, Annexure P1.
30.
13, Your Lordship. 13, Annexure P1.
Yes, please.
6.12/6 of 2010 তারিখের পরে প্রদত্ত কোনো শ্রেণীগত শংসাপত্র গ্রহণযোগ্য হবে না।
1 minute. 12.
At last, Your Lordship. Point number 6. 12/6/2010 তারিখের পরে প্রদত্ত কোনো শ্রেণীগত শংসাপত্র গ্রহণ হবে না।
So that is your case.
Yes, Your Lordship.
What is your case?
Your case at the time of verification, Your Lordship, the petitioner, the petitioner didn't produce a scheduled type certificate and any authenticated certificate from the competent authority.
Correct. So, but the single bench says that he had applied earlier. It is not his fault. How do you tackle that matter? The order of the single bench.
Yes, Your Lordship.
You have read it, Mr. Paul. It says that what is the fault of the repeat? It's just a matter of your getting your response. How do you say? What is the stand you can take? How do you react to that part? This is an admitted position. He could not produce it on that. But he is a scheduled tribe candidate. He applied before the examination, got the certificate later. So when was your interview held?
Interview in 2014, Your Lordship.
Did he produce the certificate then?
No, Lordship. At point of time, he didn't produce a certificate. In 2009 recruitment process, Your Lordship.
Go through the impugned order, page number 5, last paragraph.
Mr. Pal, relax. We are asking you questions. We are not yet deciding anything. Relax and answer the question. Use your mind. Mr. Bhattacharya, let him make an attempt. We'll ultimately ask you to
Page, last paragraph of page number 5 of the impugned order.
Yes, Your Lordship. last paragraph of page number 5 of the impugned order. Petitioner didn't process and produce a schedule caste certificate on date. It appeared he in written test and interview. The respondent counsel ought to have taken consideration that petitioner no way the responsible or delay in issuance of the certificate which he applied prior to. The petitioner did possess and produced the scheduled tribe certificate on the date he appeared in the written test and the interview. The responsive counsel ought to have taken into consideration that the petitioner no way to responsible for delay in issuance of the certificate for which he is applied prior to the date fixed by the council.
Yes, Mr. Bhattacharya.
As per date of advertisement was fixed, my lord, petitioner does not produce any authenticated documents of the schedule caste certificate. That's why, my lord, petitioner candidate not considered at the time of verification. Petitioner not produce this document. My lord, as per,
I am for the respondent number 1.
Yes. Yes.
Petitioner name. No, respondent. Can I respond to petitioner? আমার ওখানে আমার আমরা তো চ্যাপেল সবই অর্ডারটা দিয়েছি
The recruitment is complete.
Lordship, all is complete. Identical matter was heard before their lordships. Lordship director of petitioner to only produce the land loser certificate. Lordship here say, yeah, I have produced, but lordship director of respondent to apply there to land reform officer or Murshidabad anything. He and directed by the state government to produce the certificate. If the lordship he is eligible, that order is there, identical order then.
No, that is not an identical situation.
Identical lordship.
That is not an identical.
But he did not produce any land loser certificate, lordship.
It is not a land case.
It is not a land.
Schedule caste, sorry, lordship, schedule caste. I am sorry, lordship.
This is not a land case. Number one, this is a scheduled tribe, and there is no confusion about the certificate. Land losers, there was.
Land loser, lordship, I am passed the order, lordship. That is separate, lordship.
We have passed orders in 5-6 matters. That is separate.
But here, lordship, we this.
Why are you a respondent in this appeal?
Yes, my lord.
Why are you a respondent?
Yes, my lord. Sorry, my lord.
Why have you been made a respondent in this appeal?
I am made a party, lordship. I have prepared an appeal, lordship.
I am the petitioner in the respondent number 1.
In you appear for the.
I'm for the state lordship, pro forma respondent.
Please come this side.
Single bench order.
So now what is to be done, Mr. Boisho? He has the scheduled tribe certificate. It's not the same as the land losers.
No.
But he could not produce it within the cutoff date. Now what can be done?
But here, lordship, on the verification is the time. On the date of verification, we did not produce any the
Correct, he did not produce.
But he didn't. That lordship identical matter item number 9, we did not produce the physical handed certificate. But on that lordship, he did not produce on the date of verification, did not submit any the scheduled caste certificate. That's the question.
Scheduled.
No, my lord. No, my lord.
Then what is the yes?
Yes, my lord, kindly come to this.
Yes.
Yes, my lord. Before study this, I am saying this. He is a scheduled tribe candidate, not scheduled caste, and application was made at the before application was applied for the caste certificate 2009, and their cutoff date is 24 June, perhaps 2010. But the certificate has not issued by the computer. Received after the
the examination was held 2012. That has been cancelled by subsequent notification. And an examination has cancelled. Thereafter, my lord, they have issued a further notification for re-examination. 2014. And when the re-examination started, he already obtained the certificate. And though he has no fault because he applied in the 2009, and I am coming that after that cancel of the previous examination, in the second time examination, he appeared, he contested, he selected, then this letter of the invitation, my lord. Kindly see 31st October 2014 at the head, at the top, my lord. That is the right hand side, page 39. And my lord, in the middle portion, kindly see the 20th November 2014 will be the date of interview or the document and certificate verification. So now, my lord, kindly come to at the lower portion, means the base portion, that this document will be produced. What means? One, call letter, admit card. Second, call letter, admit card for the written selection, age proof certificate, address proof. Then fifth is the concerning point, that certificate regarding category SC, ST, OBC, etc., etc. So they are inviting.
No, show your admit card.
Yes, my lord.
Show your admit card. Which is the admit card? Page?
Page, my lord, kindly, my lord, sorry. Just previous, say, yes, my lord, just previous, 38 page.
This is when you originally applied.
Yes, it is a second time, my lord. First time examination is cancelled and de novo proceeding. When the de novo proceeding is going on, the cut-off date in the previous advertisement or the previous examination, that will not be applicable.
Have they said that anywhere?
Yes, my lord. First examination is cancelled.
All right.
This is the second examination, second time after cancellation of that.
Where is that? Where is a second examination? Where have they put back the cutoff date? Is there any document?
No mention, my lord. My lord, this is, my lord, kindly see in the left hand side at the bottom of this document.
Very well.
SC and EC.
We'll complete this consideration before vacations itself. Come back on Bimal.
My lord, their case is that
we will
cut-off date. Only the question of cut-off date of the production of the certificate of ST. Nothing but it is a simple question, very short question.
Very short question.
And the judgment has been.
You are Mr. Roy or Mr. Bhattacharya?
I'm Mr. Roy, Mr. Manoj Kumar Roy.
Mr. Roy, before vacation, short or long, we are going to now see the end of it. Ashwin. Good vacation. Mr. Roy, enough. Cut-off date 2010. Din dao, khali din dao. Parties is / are represented in the order of their name. Are suno.
আরে 13 হচ্ছিল হঠাৎ দেখি কি 16 আরে
Para, heard Mr. Roy, learned counsel appearing for the respondent number 1 / the writ petitioner. Full stop. Heard Mr. Chattopadhyay, learned senior counsel appearing for the state respondents. Full stop. Para. Let the matter be placed next for arguments to be concluded. under the same heading mentioned matter by date on the 19th of May 2023. You're coming.
Last day.
You're coming to court. First half.
Yes, yes.
So when, Lordship?
19th May, Friday, first half. By date.
But Lordship, here Lordship, the contempt, Lordship, he filed a contempt petition.
Mr. Roy, don't go ahead with the contempt.
Yes, my lord. I shall not proceed. My lord.
Anubha, we are not recording it.
Yes, my lord. My lord. My lord.
But there
I
is
shall
a,
not proceed.
but
I
there's a
shall not-
cutoff. There's a cutoff date for the contempt.
Yes. Yes.
কটা বাজে?
19 তারিখ হয়েছে না?
হ্যাঁ 19
লাস্ট ডে ছুটির দিন না লাস্ট ডে
ওই
কত দৌড়বো Milord, this is my application of contempt of court.
In this matter, I am appearing on behalf of the Union of India, led by Mr. Laner ASG. We have received the
Milord, only Milord, I pray for 10 minutes time. Because Milord, from the very beginning, the Honorable Court was being misled by the respondents. I will show one by one. And now, Milord,
On the last occasion, we had directed the Union of India, who is represented by ASG, to clarify certain points. You will get your time. First, let us see the clarification, then we will get your time.
Only I will submit that by an affidavit, the condemner stated that out of 49, 23 are eligible, they have been given benefit. 10 are eligible, the name has been sponsored under a scheme which is yet to be launched. And Milord, only 1 minute.
We don't tend to forget things. I am giving you where from you just now ended. The affidavits were coming from the district magistrate. Now, in one of the affidavit, there is an annexure which says that yes, A, B, C, they have been selected. They have been given a Awas ID number, but they have been allocated in a project which is yet to begin. That was the point where we started.
No, that is not the point. Because they have stated the 13 are not eligible. Milord, where is that scope, Milord? That point is taken first time in the contempt application. The writ petition is allowed. What is the prayer in the writ petition? The prayer was to give benefit to all the petitioners.
Then you have to challenge that order, because we have, after the affidavit.
Milord, after the
affidavit, we have specifically passed an order where, so far as those entitled, we have kept them within the arena. Those who are found not to be entitled, for that purpose, we have, for the time being, not looking into it.
Milord, I am asking a question to myself. Where is the power of the condemner to say that they are not eligible? Milord, if you also come to page 49 of the contempt application, Milord.
Please let us hear the Union of India, then you will get your time.
No, Milord, because Milord, they say if all the petitions are given benefit, I have nothing to say. But only if these 13 are excluded, I have to challenge, I have to submit that where is the power of the contemptor to say that these 13 are not eligible. People also be pleased to go through the order of appointment of the contemptor as a disbursing officer. Your Lordship, and the order passed by Honorable Appeal Court. The Honorable Appeal Court has expressly stated that the benefit is given to all the petitioners by allowing the writ petition. And now, Milord, the disbursing officer said, Milord, the 13s are not eligible. From where he has got the power? I am asking this question to myself. Milord, his appointment is at page 49.
Yes.
He has been appointed only to disburse the benefit.
Yes, Union of India.
Already we have received two types of report. One is a brief history of the scheme. Another,
use the microphone. We are unable
to
hear. Please use the microphone.
Nice. We have received, my lord, two reports. One was a brief history of the scheme. Another is a letter of department addressed to the Lalnet age. First report, Lordship will find paragraph 2, 4 and 5. My
এটা কিসের ভাই?
আমাদের রিপোর্ট যেটা এসেছে দিল্লি থেকে যেটা দেখছি আমার কাছে নেই দেবো Lord will find first, my lord, paragraph 2.
Lord, may I get a copy of this?
Yes, my lord, only 3 copies, my lord, I will give you.
So we first give it to the petitioner, not to Mr. Mukherjee, because Mr. Mukherjee often brings one copy and he says that after the matter is over, I will give a copy. So this time he has to suffer.
দেখুন কপিটা দেখুন ফার্স্ট আপনি দেখুন প্যারাগ্রাফ 2টা দেখুন
Yes, place paragraph 2.
Paragraph. Well, in this regard, I would like to inform that the Rural Housing Division is implementing Pradhan Mantri Awas Yojana Gramin with effect from 1st April 2016 to provide assistance to eligible rural households for construction of 2.95 crore Pakka house with basic amenities to achieve housing for all in rural area by 2024. This is vital, my lord. The ministry is not supporting financing any scheme by the name of Gitanjali housing scheme or my lord Awas Plus housing scheme. This is my lord Gitanjali. As per Union Cabinet approval, the beneficiaries under PMOJ scheme are identified as per the housing deprivation parameters prescribed under socio-economic caste census 2011 database. Further, the gaps in target of 2.95 crore house is to be met from the households from the finalized Awas Plus survey 2018 list. As on date, target of 2.94 crore houses have already been allocated to state areas which include target of 2.08 crore house from 2011 database and target of 0.86 crore houses from
We wanted a cross section. You are giving a overall picture. What will we do with 2.95 allocated to whom? We have asked you specifically, if you have gone through the order, what is the allocation in respect of the scheme in which some of the petitioners have been allotted.
Well, paragraph 4, Lordship will find paragraph 4 ID. Well, 6 line from bottom. 6 line from bottom. The details of house. Paragraph 4. Details of house, sanctions, release.
Where are you reading?
Paragraph
Details
4.
of, yes, sanctions, yes.
The details of house sanctions, release of installment of assistance completion etc. is available in public domain and can be assessed if the details such as PMG ID, name of beneficiaries, address etc. are available. But this is not available to us.
No. Who is this gentleman?
My lord,
The sign?
Mr. MVN Bhara Prasad, Under Secretary to the Government of India. My lord, Ministry of Rural Development, Rural Housing Division, under Ministry of Rural Development.
Tell us one thing. Does he want the division bench to look into the computer and search the public domain to get the information? This is the spirit of the letter. আমরা এখন কম্পিউটারে খুঁজে খুঁজে দেখবো পাবলিক ডোমেইনে আছে বলে, সে তো লোকের ব্যালেন্স শিটও থাকে, তাহলে কোর্ট কেন প্রডিউস করতে বলে ব্যালেন্স শিট? তো ইম্পর্টেন্ট
Onub Dasgupta.
Mr. Dasgupta, you do have a copy of the order dated 7th February 2023.
Seventh February order. 7th February order. 7th February order. 7th February. No.
আমায় ফেরত দেবেন, ওদিকে যেন না যায়, আমার অনেক কাজ চলে গেছে ওদিকে।
7th February.
See, the difficulty is that every day a new advocate is coming. Mr. Bhudev Chatterjee was there. He then went off. The learned ASG came. Today, on the last day, we do not recollect whether you were there or not. Now, today you have come. No one has a copy of the order. Now, this is the level of preparation, level of assistance given to the division bench in a content proceedings. And when the court will use harsh words, you will go out and say that the judges have ill-treated us. Yes, come to the second page.
Yes, ma'am. Second page.
Yes, technically the third paragraph.
But it is there
On
for
the next date.
on the next
date.
the learned advocate given the Union of India shall apprise this court as to whether the monetary benefits receivable by each of the said 10 petitioners with distinctive Awas Plus ID has been transmitted to the state government for the actual disbursement of the said 10 petitions.
Where is this answer?
My lord, my instruction is
Where is this answer? Sir, when you are holding the brief, you have appearing before a division bench. Where is the answer?
my lord, my instruction is that, my lord,
Your instruction will not do what we have asked has to be answered. Where is the answer? You are filing documents, you are filing papers, no difficulty. We are ready to read 1,000 pages also. But where is this answer? When the court has pinpointed the issue, where is the answer?
the 10 petitions of the petition are also sanctioned. Not present.
Then you have also not checked. Not only you did not check the order, after these two documents were made over to you, probably you are reading it for the first time before us.
Well, already, my lord, we have intimated the, my lord,
No,
department with
intimation.
full-
See, you are the mouthpiece. You are representing the Union of India. You are the mouthpiece before the division bench. Now, there was a categorical order, and not for once. After that, twice it has been adjourned on the same plea that it will be looked into, the information is awaited. Where is the information? This passing of the buck business is going on for long time. State is showing the central ministry and central is showing the state. Ultimately, where the petitioners will go.
Well, we have sanctioned the money. Well, state
Where
government.
is that statement? Sir, where is the statement? You may have sanctioned the money. During the annual budget allocation is there. in respect of all departments. Will that suffice when there is a specific order that give us this information?
The state government, after receiving the fund, they will allot the money in favor of the beneficiary. We have
Sir, plain and simple question. The little bit we understand. If somebody has been selected for being given a benefit, his name shall figure in any list, any document, a copy whereof will be with the state and with the central. Now, please let us know what has happened to these 10 petitions. That was our query. This is the level of assistance we are getting. একটার কোনো উত্তর নেই।
স্যাংশন করে দিয়েছে, কিন্তু সেটা না মাইলো বলছে সেটা কোথায়? টাকাটা স্যাংশন করেছে ওটা তো নেই লেখা নেই। না, টাকাটা স্যাংশন করেছে এটা লেখা নেই। হ্যাঁ, স্যাংশনটা তো করেছি সেটা তো লেখা নেই না। Of the letter addressed to the learned additional solicitor general. In addition to the above, the Abbas Plus survey started in January 2018 with initial deadline of 31st March 2018. This deadline was extended 4 times till 13th June 2018, 13th September 2018, 13th November 2018, and finally till 17th March 2019. During the Abbas Plus survey, the state UT had identified all the eligible households who were not included in the SEC 2011 list as on date against the total identified 0.56 crore households. During Abbas Plus survey, the state of West Bengal has already deleted 0.17 crore households due to them being ineligible for assistance under PMJ, and 0.39 crore households are remaining. The ministry has already allocated fund a full and final target of 11,36,488 houses from finalized Abbas Plus list of the state of West Bengal. Against this target, the state has already given sanction to 11,02,060 beneficiaries from the households remaining in the eligible list of Abbas Plus database.
Sir, the difficulty is that we are sitting here to adjudicate a matter.
Yes.
We did not ask for a write-up. We need a specific answer. Where is that? What will we do whether 11 crores or 11 lakhs have been given the benefit? What shall we do with that, knowing that? The 11 lakhs are not before us, 11 crores are not before us.
Only about 10.
Only 10.
I shall send another message to that department.
হ্যাঁ, তো টাকার কারোর কাছে হিসেব নেই. No one has any. See, somebody has to take responsibility, either the central or the state. And in this sort of situation, from the documents what you the state and the central ministry has filed, it is clear to some extent there is a joint responsibility. Maybe funding is from you, actual disbursement by the state. But we want to know about these 10 petitioners. And this undersecretary has the audacity to write a letter to the ASG, which is being placed before the division bench, that the information is available in the website. কি করবেন দেখুন, এ টোটালি ফ্রাস্ট্রেটিং। যদি আপনি
Well, give me one. Two.
It is correct, Manor. They are not providing any financial assistance to Gitanjali State.
read at the ministry is not supporting, financing any scheme by the name of Gitanjali Housing Scheme oblique Awas Plus Housing Scheme. Now you come to the affidavit of the district magistrate. With the chart, the affidavit with the chart.
ওরা যে এফিডেভিটটা দিয়েছে, ডিস্ট্রিক্ট ম্যাজিস্ট্রেট যে এফিডেভিটটা দিয়েছে, চার্ট যেটা দিয়েছে দেখুন, ওটা দিয়েছে আপনাদের দিয়েছে দেখুন, এই যে দেখুন, রেজিমেট করেন নাকি কোথা কি 1922 হ্যাঁ দেখুন 19
তাকে জন্য বলছি
এই যে 1922টা আপনাদের যেটা
Affidavit of compliance filed by the district magistrate.
কমপ্লায়েন্স রিপোর্ট এই তো 1922
পূর্ব মেদিনীপুর।
ধরুন 1922 কমপ্লায়েন্স রিপোর্ট ইনফর্মাল এভিডেন্স প্যারাগ্রাফ কত বড় 10 Both Gitanjali and PNG scheme are specifically housing scheme.
Further say the board Gitanjali and
Mr. Mukherjee, kindly come to page 3 of that.
Yes.
Have you come to that
I said that
page?
I said that
Second column.
I said that.
Registered Awas Plus beneficiary. Awas Plus ID given.
Yes.
Then nil.
I said that.
Then project is yet to be started. Now you gave us an impression, the affidavit, why this district magistrate should not be proceeded with, because he in the affidavit gave an impression that this Awas Plus Yojana is a central government project wherein funds are being allocated by the center. So we have given them an ID identification number, and our job is over. Now, it is coming in writing that Awas Plus Yojana is not a sponsored scheme by the central government. What is your answer to this?
Central scheme.
Pradhan Mantri Awas Yojana is a central scheme.
Yes, please use the microphone.
Pradhan Mantri Awas Yojana is a central scheme.
Now you look at there, they clearly say that is what I made you read.
Even
Paragraph 2.
paragraph 2 देखो. Paragraph 2 देखो. ये तो देखो. Awas Plus.
Housing scheme.
Awas Plus.
Underline portion. The ministry is not
Awas
supporting
Plus.
financing any scheme by the name of Gitanjali Housing Scheme / Awas Plus Housing Scheme.
এটা লিখেছে যে আমাদের কোনো টাচ নেই আবাস প্লাস এবারে আপনি এটা দিতে এটা যোজনা 23% ওয়ার গিভেন বেনিফিট পেয়ে গেছে ফাইন্যান্সিয়াল স্কিমে পেয়ে গেছে সেদের above 23 beneficiaries were selected or identified as per PMAYG. এটা যে সেন্ট্রাল স্কিম তো প্রধানমন্ত্রী আবাস যোজনা তো পেয়ে গেছে আর এটা আবাস প্লাসটা আপনাদের আবাস প্লাসটা হচ্ছে স্টেটে দেখুন আবাস প্লাসটা হচ্ছে স্টেটে যে অ্যাকর্ডিং টু দিস এটা মিনিস্ট্রি ইজ নট সাপোর্টিং ফাইন্যান্সিয়াল এনি স্কিম বাই দ্য নেম অফ গীতাঞ্জলি হাউসিং স্কিম or Awas Plus Housing Scheme as per Union Cabinet. এবার এটা হচ্ছে কি প্রধানমন্ত্রী আবাস যোজনাতে
Give me some time so that I can talk with this combination from the central
We
government.
cannot hear you, Mr. Mukherjee.
Give me some time so that I can take the matter to the district magistrate. What is this Awas Plus and Awas Pradhan Mantri Awas?
What will he take? He has filed an affidavit in which he has given a tabulated sheet which forms part of the affidavit. It says Awas Plus ID number is this. And then he says, see, the difficulty is that this bench reads into the papers, no?
প্যারাগ্রাফ জিজ্ঞেস করুন পেজ জিজ্ঞেস করুন
Now we come to the affidavit affirmed on 12th of July 2022.
জুলাইটা বেরবেন আপনাদেরটা
কোনটা দেখছেন
আপনাদেরকে জুলাইতে একটা করেছে জুন
Have you come to that? Come to more specifically paragraph 2B.
Yes, Honor. As per field survey report from the end of block development of Hon'ble Kolkata development block and executive that is.
Have you come to that? How you come to after the 10 names,
Yes, Honor.
the
Each having
unnumbered portion. Please read it loudly. Please use the microphone. Please use the microphone. Read it loudly.
As per field survey made from the end of the block development of Bhagwanpur and development block and
Not required. Not from that.
that
After the names. 10
yes,
names.
each having mud houses and they are under the queue of top priority and first preference will be given to the 10 petitioners. When our scheme under the MORD will be launched
What does
by the
it
central
mean?
government.
MORD? Ministry of Rural Development.
Ministry of Rural Development.
Central government.
Central government.
Now this so he has given an impression before the court that this Awas Plus is a central government scheme. Now the letter comes from the undersecretary that Awas Plus scheme is not a central sponsored scheme.
Then I shall have truth.
Are you taking us for a ride?
No, no.
We don't mind during the
Parliament,
pleasant weather to go for a ride,
lunch
but
by the
not
central
now.
State authority will
For the first time I came to know
Enough, enough, Mr. Mukherjee, enough. This matter has consumed enough time.
Awas Plus scheme under Ministry of Rural Development will be launched by the central government. The state authority will implement the scheme immediately when it will be launched by the.
that is the information given to the district master. That's why we are. But now I have from the
No.
वो खास बात देऊ ना माइंड अप्लाई वारंट इशू कर दी
Behalf of the Union of India, two documents have been made over to court. The first one is a letter dated 20th April 2023, written by M. V. N. Vara Prasad, VARA Prasad, Under Secretary to the Government of India, Ministry of Rural Development, Department of Rural Development, bracketed Rural Housing Division. The other document is titled as Brief Note on Pradhan Mantri Awas Yojana dash Gramin bracketed PMAY dash G, all caps. It appears from next Guru, it appears from paragraph 2 of the letter dated 20th April 2023 that the Ministry of Rural Development is not supporting / financing any scheme by the name of quote unquote Gitanjali Housing Scheme / Awas Plus Housing Scheme. আচ্ছা ওই দুটো ইয়ে হচ্ছে ওগুলোকে টেকেন অন রেকর্ড ওই যে বললাম না এটার আগে the two documents are taken on record. On the other hand, we notice from the compliance report filed by Purnendu Kumar Maji, the district magistrate and district collector, Purbo Medinipur, dated 12 July 2022, that 10 persons named in paragraph 2 small p of the said compliance report are under queue of top priority and first preference will be given to these persons whenever the Awas Plus scheme under quote unquote all caps MORD will be launched by the central government. Next, there, it is thus the contradiction between the statements made by two responsible government officers are apparent on the face of it. The central ministry on one hand is saying that they do not sponsor, saying that that they are not supporting financing any scheme by the name AWAS, AWAAS plus housing scheme, while the district magistrate Purbo Mednipur says that AWAS plus scheme is under Ministry of Rural Development to be Ministry of Rural Development and will be launched by the central government. This court, in the aforesaid contradictory statements, are completely at a loss and is not in a position to either rely or accept the statements made by the additional secretary in the letter dated 20th April 2023, as also the affidavit, as also the compliance report in form of affidavit filed by the district magistrate Purbo Mednipur on 12th July 2023. The aforesaid facts and circumstances, বলে দিন কবে আসতে বলবেন। The aforesaid facts and circumstances, the Purnendu Kumar Maji, the district magistrate and collector Purbo Mednipur, who affirmed the compliance report affirmed on 1st August 2022, who affirmed the compliance report on 1st August 2022, and MVN Varaprasad, Under Secretary to the Government of India, are directed to be personally present to explain their respective statements as noted herein above on
দুজন ডিএম কে বলে তাই ডিএম আর দুজন ভালো ভালো
হ্যাঁ দাও না একটা ডেট দাও, দুটোর সময় দিয়ে দাও। আমার তো অসুবিধা নেই, আমি তো সিঙ্গেল বেঞ্চে আসবো, আমি ভেঙে নিতে পারবো যখন খুশি।
ভিডিও কল
June 2023 at 2 p.m. Let a copy of this order be communicated respectively to the district magistrate and such and such under Secretary Court of India, the registry of this court.
ফিক্সিং চলুন কবে হলো একটা অবধি যাচ্ছেন আপনি কবে তারিখটা
13th June 2 p.m. Under Secretary and the District Magistrate are to be present. এই ম্যাটারটা দ্বারা who appears in the Port Blair matter?
My lord, I'm appearing for respondent number
Anybody
1 to 9.
appears in the Port Blair matter, item 1?
My lord, I'm appearing for respondent number 1 to 9.
Yes. Who appears for the appellant?
14 June.
Yes. We do not think it will be possible for this bench to assemble for this matter. So we are releasing the matter. Let it be placed before the appropriate bench.
Let it be placed before the circuit bench, my lord.
Very well. Very well.
Before the Chief Justice.
Yes. Let it be placed before the Honorable the Chief Justice to take a decision on the matter. He may. Ashun. Party this / are represented. Please give your names on the chat box.
My lord, I have already given Siva Balan.
Yes, Mr. Shiva Balan, we can recognize you by your voice. But please give your name on the chat box.
Yes, my lord.
Party this / are represented in the order of their name / names as printed above in the cost title. Full stop para. The business of this court does not permit that this matter can be taken up because it can be taken up in view of the fact that this bench is an irregular bench for a refined court. Accordingly, the matter stands really MAT blank of blank with can blank and can blank. Dudo can stand blank of blanks and released from this bench. The matter will be now placed before the Honorable the Chief Justice for appropriate assignment. Parties to take steps. Yes, we have released the matter to be placed before the Honorable the Chief Justice for appropriate assignment. Parties to take steps.
My lord, my submission is praying for placing before circuit bench.
That the Honorable the Chief Justice will take, will decide.
We cannot do it. We cannot do it. It is the prerogative of the Honorable the Chief Justice.
Correct.
Oblige, my lord.
Yes.
But I am for the appeal.
Item number 3 and 4. In 4, I appear for the appeal.
Yes, your appeal has also.
My lord, subject to correction, my lord, I am led by Mr. Gupta. My lord, he is on legs, my lord. Led my learned senior friend if starts, my lord. He is my lord also, my lord.
Everything, Lord, arise out of appearing for the appellant.
I am also appealing for the two appellants. Mr. Kaur is.
No, but the board gets the primacy of to address this because the board took the leave first.
First, right.
First.
But he
So let
saying
the
that-
board submit first and then we hear anybody. You appear for the candidates.
Yes.
So therefore
He is
we
saying
hear.
that Mr. Gupta is on legs, on different.
No,
that-
but then Mr. Gupta specialist took time for us and we fixed 3 p.m. today. So the board has to begin its case. Mr. Gupta,
I don't mind, Millard.
Yes.
I don't mind.
Yes.
But I am the most affected person.
Correct.
Board got the opportunity of hearing. I didn't get it at all.
Fine. We'll come to you after the.
My
vote. Mr. Kaur is for?
I am also for now the candidate.
No, not candidates, the appointees.
The appointees, sorry. Appointees who have lost their.
Correct. So you and Mr. Bandopadhyay are for.
We are on the same.
Correct. You're for the board, Mr.
My lord,
Biswas.
I'm for the
Who
board.
appears for the appellants? For the writ
My lord, I'm for the
petition.
appeal.
You're for the writ petitioners. Mr. Tarun Jyoti Tiwari, Mr. and who you appear? State response. Anybody else?
My lord, I have served everybody, my lord. This is my affidavit of service.
And what about the school service commission or whoever it is? Primary board? They are not represented? Or the board is here?
Board is here.
My lord, I am filing my affidavit.
And only one thing, today morning, Millard, the order on appeal
Yes.
has been modified by the learned single judge.
Yes. What is the modification?
Modification is, Millard,
My lord, modification is the number.
it is a number.
We'll come to it, Mr. Tiwari. Please take your seats. Let us go through the order first.
My
And
lord,
then.
before the my lord impugned order, my lord, some facts. My lord, may I narrate, my lord?
Not now. Let the impugned order, let us read the impugned order, then you narrate as
My
many facts as.
My lord.
And
The situation of the High Court, my lord. My service is gone, but I do not know.
yes, you are appearing for some of the.
Yes, but I do not have any papers with me.
Right. Let us see read the impugned order and then only we come back to you. Please take your seats. And you can ask Mr. Gupta to come because he took lead.
কাগজ নেবো সবখানা লোক বলেছি সেখানে কপি দিতে হবে না পাচ্ছে পড়ে যাচ্ছে কোর্টে
Apart from one system doesn't apply. More of the evidence that না না আমাদের একটা গ্রুপ আছে হবে না কারণ লক্ষ্মীরা আসছে আপনার এটা আমার পড়ো এটাই আমার আরো বাকি ওটা সময় আমি কিন্তু সেটা এই সেক্টরটাতে
Before proceeding further, please have a look to only one paragraph of the judgment, paragraph number 19.
Paragraph?
19. Well, this is the total consideration of the entire submission made by me.
Yes.
The board placed some judgments before me in support of niceties of legal principles, which I do not find have any applicability in the face of the magnitude of the stinking corruption in the recruitment exercise of 2016 conducted by the board. Those judgments are not required to be mentioned at all in the factual situation of the case, as those are bright stars of the space, much above the ground realities in which unemployed youths live with tears in their eyes, because this recruitment scam is a crime against the society and also a fraud, where the board and its former member as well was well aware of the rules of recruitment, but cared a fig and started to play a hoodwink all concerned. I will only say that fraud unravels everything. Milord, we had made certain submissions with respect, Milord. None have been considered. Now, Milord, we have, Milord, apart from making oral submissions, Milord, we had filed a written notes of submission before the Honorable Court. Milord, since, Milord, nothing has been recorded insofar as my submissions are concerned, therefore, Milord, I take recourse or resort to, Milord, the written notes of arguments that we had filed. But I'm sorry, Milord, these are not in, Milord, official. But, Milord, in the records of the court, Milord, you should find this, Milord.
Yes.
But just hurriedly, Milord, I'll take your Lashima. These are in the form of bullet points of what, Milord, I had submitted. First is all untrained candidates confirmed by petitioners on being questioned by the court. Or Milord, the petitioners accept that they are untrained candidates. Second is whatever were the grievances, Milord, this was known to them contemporaneously. Milord, no contemporaneous challenge made. All challenge, Milord, after, Milord, expiry of the panel. Then 3, infraction suo motu cannot be a cause of action, but the question is whether the cause of action can be kept alive to such a subsequent period. Then 4, in all the 2016 recruitment process, 7 panels were published from time to time. All panels expired long before the present petition was filed. Questions for adjudication whether a belated challenge can be thrown. B, whether persons are entitled to any relief after the life of the panel expires. Then 2016 was a district-wise selection, where now, Milord, the board undertakes the entire selection, but previously, Milord, it was the councils which had to do it. 2016 was a district-wise selection, whether in a single writ petition, different district petitioners can join issues simply by making the board a party. Then D is, Milord, burden of proof. Milord, we have said that, Milord, burden of proof was not discharged by the writ petitioners. Then E, whether the writ petitioners can rely on materials which have been brought before the court on subsequent dates. Then F is very important. Whether trial takes place in writ jurisdiction in exercise of Section 165 of the Evidence Act. But here, Milord, the Honorable Court suo motu exercised powers under Section 165, called, Milord, many witnesses, examined the witnesses, and, Milord, based on whatever had come out in evidence, Milord, this entire exercise has been undertaken. Therefore, Milord, this is a very important question, Milord. 165 is, Milord, exercised in course of trial, where when the parties bring their witnesses and when the witnesses in the witness box, Milord, if the court feels that certain clarificatory questions are to be put, or some issues are to be brought forth, then my lord, the court can pass, my lord, put questions, my lord, in exercise of powers, my lord, under section 165 of the Criminal Procedure Code. But with respect, my lord, the court or the High Court, the writ court, which is exercising extraordinary jurisdiction, my lord, in my respectful submission, no trial is held, and therefore 165 is inapplicable. Now kindly take, my lord, G. In writ petitions, evidence or proof is annexed in the writ petition. My lord, Bharat Singh's case, my lord, we had referred to, where, my lord, the Supreme Court has said, and it has been followed all throughout, that, my lord, in a writ jurisdiction, whether you are the writ petitioner or the respondent, make pleadings and annex evidence in support of that. Then, my lord, H, my lord, again, my lord, 165, we have said a lot of things about 165 in H and I. Then J, where since the court was concerned about, my lord, the powers under 165, my lord, we have said that even going by 165, the burden of proof is on the person who alleges something. My lord, sections 101 to 104 of the Evidence Act, my lord, we had relied. Then again, my lord, 5. My lord, we have relied upon several judgments, my lord, on 165. And then, my lord, the board's case that, my lord, we have made out. Now, my lord, this is, my lord, only the gist of the submissions that I had made and the notations of only the citations. But, my lord, details arguments were made, but with respect to nothing has been considered.
Mr. Dotto, we have gone through the order impugned. There are some very hard facts involved. We have understood the legal tenor of your defense. What about these hard facts which are on record? How do you tackle these hard facts about aptitude test, about granting of marks? What about these 121 pages spiral binding, etc., which has been discussed? And these are very hard facts. So how do you meet these hard facts? And how have you met them before the single bench on affidavit?
First is, my lord, so far as this recruitment process is concerned, my lord, there are 2 judgments of this Honorable Court where, my lord, a host of writ petitions were, my lord, considered and dismissed. My lord, by 2 Honorable Single Judges of our court, both the judgments were placed before my lord, before the Honorable Single Judge, saying that the Honorable Single Judge, 2 Honorable Single Judges, did not find any reason to go into these aspersions, and these were dismissed long back. No appeal carried to the higher bench. Yet a thing which has already been disposed of and put to rest, my lord, these have not been challenged. Therefore, my lord, a 3rd writ petition or a 3rd batch of writ petition, in my very respectful submission, is not maintainable.
Yes.
Where the Honorable Single Judge, with utmost respect, my lord, does not even, my lord, refer to the judgments that I have placed. These are 2 unreported decisions of this Honorable Court. So this has been put to rest.
So what are the deficiencies of those candidates whose appointments have gone? First, that they are untrained.
Yes.
Second, they went through an aptitude test, which was really not an aptitude test. Third, they were marked marks in an aptitude test, which is, according to the Honorable Single Bench, absurd. It could not have been so marked. Fourth, their other academic performance in higher secondary and TET, who did not correspond to their performance in the interview. So what is the Honorable Single Bench? We are having a loud conversation. No making up of mind right now. It's a conversation.
Right.
Now, after all this, the Honorable Single Bench has, from paragraph, kindly read the operative portion from paragraph 21. Now, if all this has happened, and supposedly if all this is an admitted position from the cold hard facts which have been brought on note.
Right.
Now, what has the single bench directed concurrency? That it has not put you, it has not thrown away the candidates. What it has tried to do, kindly read with us from paragraph 21.
Yes. In such circumstances, I allow the writ petition.
Number one, the writ petition is allowed.
Yes.
Second, the appointment of...
May I only add one sentence?
Please.
In such circumstances would mean pleading, evidence, consideration and proof thereof. I reserve my breath to demonstrate before your lordship that nothing was in the pleading. Then, the appointment of all 36,000 more or less candidates who were untrained at the time of recruitment in 2016, recruitment process conducted by the board in the post of primary teachers are cancelled for various reasons as have been elaborated below. My lord, neither the board nor the petitioner has provided any such figure to the Honorable Court. Number one. Number two, none of them has been made parties. Even, my lord, some people in representative capacity were also not made parties. Therefore, all these persons, whether it is 36,000 or whatever is the actual figure, my lord, were not heard.
What was the requirement of recruitment at that time? They had to be completely trained.
No. There were, my lord, relaxation by the NCT. I'll place all those.
We need to see that rule.
Yes, MHRD had given the relaxation.
We need to see
extended
that.
the time.
Yes, then.
But these are not considered with respect, my lord, by the so are cancelled for various reasons.
So you may have difference with the expression in the third line. All 36,000 who were untrained.
Yes.
No, but they began as untrained candidates.
Yes.
Then
But subsequently trained.
Then let us proceed. The
When
board
relaxations were granted, then the board, para 22, the board shall immediately arrange for a recruitment exercise for candidates who were untrained at the time of recruitment, including candidates who have obtained training qualification in the meantime.
Right.
Within a period of 3 months from date, only for the candidates who participated in the 2016 recruitment process, where both interview and aptitude test of all the examinees shall be taken, and the whole interview process has to be videographed carefully and preserved. It will be a recruitment process under the same rules and the legal procedures under the 2016 recruitment process was conducted. No new or other candidate shall be allowed to take part in such recruitment test. The primary teachers who are employed now...
we pause here for a moment, that which means, subject to correction, you are not thrown out. You are not eliminated. Number one. Number two, you remain in the room.
Correct.
No outsiders are allowed in.
Correct.
The process is repeated. You were untrained. You went through a training in way of a dubious process identified by the Honorable Single Bench, in way of marking, holding aptitude tests, subject to, of course, arguments. So what the Single Bench says, repeat the process for yourself, come back trained, come back with an interview, come back with an aptitude test and get back your job. It's not a throwing you to the wolves. So how do you respond to this position? Why, if the factual situation stands what it is, then why should this process not be willingly repeated by on the face of it? These are questions. You may answer them.
Right. Then, my lord, para 24 says, if any candidates who have appeared in the 2016 recruitment process has crossed the age bar in the meantime or will cross the age bar within 3 months from the date, they shall be allowed to take part in the recruitment exercise. Crossing the age bar will now not create any impediment for them to participate and get selected in the recruitment process. The whole imbroglio, including corruption involved in the matter, has taken place due to the former president of the board who knew the rules of the recruitment but violated the rules, and therefore, if the court thinks the entire expense for holding the new recruitment can be realized from the estate of the former president of the board. Now, my lord, first thing first, what was there in the writ petition? And what was there before the court to, my lord, adjudicate and give or render these findings and the consequential directions? But we need to look into that. Well, kindly allow Mr. Kumar.
On the same boat?
Yes.
On the same
note.
You know, kindly take me, Lord, page 90. I am on the scope of the writ petition. My Lord, a completely third case has been made out. There's no pleading with regard to this. My Lord, kindly first take page 88. What are the grounds? Page 88. That the department should have acted justly, fairly, constitutionally, but they have acted absolutely illegally, unconstitutionally, etc. And then number 2, department being a statutory body should have valued the fundamental rights, but here they have flouted. 3, the department has recruited non-trained candidates after expiry of the relaxation given by the NCT, but not recruiting the petitioners. This is absolutely factually wrong. This was done within relaxation period. Now 4, board has committed a complete injustice and illegality by not publishing the merit list. 5, board has committed fraud upon the non-trained candidates and did not follow their own notification. Now 6, for the present petitioners deserve equal rights which the non-trained candidates got during their appointment. 7, mode and manner in which the respondents have acted abundantly violates fundamental rights. 8, the board has not complied with any procedure of law in acting in any manner as more fully stated here in our. 9, the respondents are public officers discharging statutory functions incumbent upon them to act in accordance with law. Then 10, any other grounds will be taken at the head. Then kindly take page 90. The prayer portion. Prayer A, Rule 26, etc. dispense with. B, mandamus. 1, to act in accordance with law. 2, to direct the authorities to file a report disclosing name, numbers, rank, category of all non-trained candidates who have been recruited till date the primary school TET 2014, including date of recruitment. 3, to direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given. Therefore, they also want that they be appointed. Now 4, to recruit the petitioners by giving them the same benefit by which other non-trained candidates were recruited by the board following such and such. Then 5, to direct the authorities to publish a merit list. 6, to protect the records and documents relating to recruitment procedure and selection of primary teachers. Then Sashirai, send the records. Below, your lordship will not find a whisper in the petition regarding aptitude test, any wrong procedure being adopted, except, my lord, that relaxation period was over, appointment was given. Why untrained candidates were given upon facility like that, whereas petitioners who are also untrained were not equally treated, treat us equally. This is the entire scope of the writ petition. My lord, wherefrom the learned court went into the aspects, my lord, that it delved in detail. My lord, what was the basis of doing this? My lord, what was done actually is, my lord, on behalf of the petitioners, a compilation was submitted, unaffirmed, containing some allegations. The learned judge, my lord, there is no affidavit. It was taken on record, and on the basis of that, the court started proceeding. The court directed the board to submit the list of the interviewers who had interviewed the candidates, took the aptitude tests, etc. A long list was given, there was 31 of them. 31 of them examined them. The questions are put by the court itself, and those persons were the teachers who the interviewers, they were examined. And the court was acting, Lord, I will say, court was acting as a prosecutor, as if when the matter was pending investigation before the CBI. It was the CBI will be looking into the criminality aspect, but criminality will depend on illegality also. Therefore, how can the writ court at this stage point out that these appointments are wrong, illegal, not following the rules? Now, what is aptitude test? Hard facts, your lordship said. What are the questions put? The point is that five marks are allotted for interview, 5 marks for aptitude test. The questions that the court was pleased to put before these interviewers was, have you segregated those marks? Kindly will not recall that this is an examination of the witnesses in respect of events which took place 6-7 years before. Some said yes, I allotted marks differently. Some said no, jointly, together. Now, what is an aptitude test? What is an interview? There is hardly any difference, as I see it, my lord. In the interview, some questions are asked, answers are obtained. In the aptitude test, also the same thing. In addition to that, my lord, the demeanor of the candidate, his smartness, whether he can communicate effectively. My lord, these are aspects which are, and whether they are able to communicate their views, because they'll be teaching the students. These are, my lord, asked from the candidates. Now, my lord, the difference is not much, and 5 marks each. Whether, my lord, the marks were allotted separately or they were jumbled up, my lord, this is, the court proceeds merely on the basis of the statements of these 30 persons, interviewers. And they are being interrogated when 6-7 years after they had sat in the boardroom to take interview. What they did they allot separate marks, or did they allow marks jointly in respect of both together? What do you mean by aptitude test? These are the questions put. Now, and simply on the basis of that, the court holds the appointment to be bad.
Where are the recruitment rules?
The recruitment rule is at page,
particularly with regard to training and with regard to aptitude, a lot of aptitude
yes,
tests.
153.
Let us see the rules.
153. 2C. My lord, kindly take first, my lord, section 2C at page 154. What is an aptitude test?
Let us see the section regarding training and the relaxation.
No, that is not yet. That is in the Ministry of Human Resource Development Department. They under section 23 of the
They're part of your
the Central Act. They have the power. MHRD has the power to relax the training qualification for particular periods, and here your training qualification was relaxed with the condition that this is relaxed.
Just 1 minute. But that important relaxation in view of the, is in the notification itself, the Parliament has taken the decision. Therefore, the central government has extended the time up to 2019. They have to be trained. Just one fact I add, writ petitioners also untrained.
True. We'll come to you, Mr. Bandapad. Yes, Mr. Gupta.
Yes, my lord, the relaxation, as your lordship, my lord, put the query to me. The relaxation was granted by the Ministry of Human Resource Development Department to the state of West Bengal and some other states.
Where is the
Page
document?
135. Page 135. 140. Sorry, 137, my lord. 137.
140.
135.
There are two stages in which relaxation was granted. One was at page 140. This is the second relaxation. 140. This is the second relaxation. There was a prior relaxation also. আরে বাবা সেটা তো প্রথমটা কোথায় দুটো ছিল রিল্যাক্সেশন দুটো ছিল Milord, kindly take page 140, Milord. Kindly come to paragraph 7. Now, therefore, in exercise of the powers conferred by subsection 2 of section 23 of the RTE Act, the central government hereby extends the relaxation to the state of West Bengal in respect of the minimum teacher qualification norms notified by NCT as published in so and so, insofar as they relate to classes 1 to 8 as under. 1-year diploma in elementary education for appointment of a teacher in classes 1 to 5. We are concerned with this. Classes 1 to 5, this is 2-year, not 1 year, 2-year diploma course. This relaxation is granted. This is a training qualification. Then kindly turn over, my lord. The above mentioned relaxation shall be valid up to 31st March 2016 and shall be subject to following conditions, namely, as specified in the aforesaid notification of NCT, the government of West Bengal shall conduct TET in accordance with the guidelines dated 11 February 2011 issued by the NCT, and only those persons who pass the TET can be considered. Therefore, though training qualification is relaxed, TET is met, remains compulsory.
So in other words, sorry to interrupt you, you recruited untrained.
Untrained.
And then you trained them.
Yes. And
Show us where you trained them.
This notification says that the trained will get preference in the matter of appointment, and when the trained are exhausted, then untrained are to be.
There's no complaint on that.
No,
there's no
complaint on that. And all these persons were subsequently qualified, but that is neither here nor there. It's a question of appointment, whether given rightly or wrong.
That's right. Now then, thereafter you train these persons. These untrained teachers whom you took, thereafter, according to the board, they got training. Where is that statement?
No.
Where have you stated that?
These persons who were appointed at the relevant time, they were all untrained.
Correct.
And the challenge is to their appointment, not whether they were subsequently qualified or not. That's not the issue.
Very well, but then you still gave them training and they were trained subsequently.
Yes, because the board doesn't give them training. They obtain training from different institutes. It's different.
The single bench has taken notice of the fact that they have been trained. Paragraph.
Yes, they have been trained. I do not know from where the single judge got it. But in any event, otherwise their services could not have continued.
Kindly see paragraph 22 of the judgment impute. There's something in bracket. 302. For recruitment exercise, so candidates who were untrained at the time, now we are including candidates who have obtained training qualification in the meantime.
Yes, yes.
So some of the candidates have obtained training qualification in the meantime.
Yes. Otherwise, they could not have continued in search.
Correct. So if they have obtained training, all that we are asking you, you know your case best. We are only asking you to give us an idea, an impression of what is happening before us.
No.
If they obtained a training we may be wrong, correct us. If they obtained a training qualification in the meantime, which means after they obtained the training qualification within the period granted to them by the page which you mentioned, then they have availed of the relaxation.
Of course, yes.
So they can be allowed to be enforced. They should. So that is the point. Where does it come from? The papers we want to find out.
Whether they obtained the qualification subsequently.
That's right. After joining.
After joining. Of course, my lord, they are not one was implemented.
Correct.
Therefore, my lord, board, it is for with the respective DPSCs, the district primary school councils, to tell it before your lordship. Not a single DPSC has been implemented.
Very well. Please continue in your own way.
But the training is it on record? There is nothing on record.
Just 1 minute. After that, just permit me.
Yes, of course.
But in my petition, I have annexed all the documents that we have got the training, got the certificate. Number 1. After the certificate, we have got it. We have been giving training benefit. Number 2. Number 3, we were originally appointed in grade B. Then immediately after the obtaining of this certificate, we were upgraded to grade A by the board itself. All these facts in my petition, sir.
And why did the board not place this on affidavit before the single bench?
The question, this is not in the writ petition. No, nothing. We have not been paid party.
One of the issues against you was you were not you were untrained. So why did the board not place it?
Kindly just may I crystallize the point? Just
Yes.
In the advertisement, it has been said, if you are untrained,
We are trying to concentrate.
just I am making.
No, you make your submission. This is not we are trying to focus on the opposite.
I am
part
coming.
of the
I am coming, Millard. The point which, if I have understood your losses correctly,
Yes.
in the advertisement it said, trained, first priority, untrained with certain qualification, but you have to qualify the training certificate within a period of 2 years from the appointment. Correct, Millard?
Yes.
This has been, we were selected, then we have got our training course, we have got the certificates within the period of 2 years. Now, Mr. Gupta has shown you lots of 2015 and 2017, Millard, 2000 up to 2015. In 2017, this sentiment in my petition, it is there, just take it from me, Millard, for the time being. 2017, the central government has said again, last time it is being extended up to 2019. All training semesters should be done within March 2019. That has also been done in our case. Therefore, the point which is really, if I am right, striking, that ultimately I have been trained, since your lordships have said this observation. Ultimately, I have trained. Papers are in my petition. I will show it. And because of the training, I got the training salary and upgraded by the board.
Therefore, no, we are not saying anything which is in the nature of expressing the final mind of the court. We are discussing all it.
All right. I am taking it that way.
We are not saying.
I understand.
In capital words. We are saying in small words.
I am understanding, but I am trying to if I have correctly understood your lordship's mind, possibly this is the answer.
Correct. Therefore, if you come now to paragraph 22 of the judgment,
Millard, just paragraph 22
of the impugned judgment.
Yes, I am coming, Millard. Since it is not be tallying with me. Millard, kindly come to
para 22.
Yes.
Now, if you please read paragraph 22, the first.
Paragraph 22, yes. The board shall immediately arrange for a requirement exercise for candidates who are untrained at the time of recruitment, so and so, who have obtained so and so. This is certificate.
Now, what is the scope of this if the
Kindly take it very, very, Millard, kindly appreciate this. How many times I have to give this fire test? Does it depend? Is it depending? Is it supported by any exercise of law?
Therefore, Mr. Bhattacharya, we stand at one point somewhere that getting a training is not an issue.
No.
Getting a training is not an issue. So that part goes. Second is now, because of the observations of the Honorable say findings regarding interview and aptitude test, whoever is there in the room, untrained and trained in the meantime, has to go through the interview and aptitude test alone.
Yes.
We'll come to that issue as we come. Yes.
I wanted to point out
On the microphone, as much as you can take the microphone. Normally difficult to take the microphone from Mr. Bhattacharya. Yes.
I'm very much
Mr. Bhattacharya doesn't require me.
The only thing that I wanted to point out is that Lord NCT permitted recruitment of untrained teachers subject to the condition that they should qualify within a period of 2 years.
They have done that.
And that has been done. So, my Lord, question of considering any untrained candidates would not arise at all. It's a non-issue.
Correct. So therefore, following the process of elimination, subject to this training part, we eliminate.
Correct.
Now we come to interview and aptitude.
Absolutely. That's the crux of the matter.
Mr. Gupta will say, Mr. Gupta has not given charge.
So
One paragraph has been given by the learned single judge, picked up 22 cases, giving the numbers, and take my paragraph, one paragraph I will show how much number I have got Forget about interview in an academical.
Let us see. Yes, Mr. Gupta.
Milord, as I submitted, Milord, on behalf of the petitioners, a booklet was filed before the court. Not an affidavit. In a spiral binding, some sort of a booklet was filed. Some allegations, some documents, etc. were there. More than 100 pages. Now, Milord, the learned court picks up some documents from there and proceeds to deal with the matter on the basis of such documents. Some of such documents included this aptitude aspect and the further allegation that those with lesser academic marks were awarded higher marks in the
Let us go back to the recruitment rule again to see that provision first.
Lordship.
How it should have, what is laid down in the recruitment rule?
153 it starts, Lord. 153 it starts.
157.
Rule 8 at page 157. Milord, your lordships are now going into the aptitude test and interview aspect. But before your lordships go into this, I beg to remind your lordships that this is not a case made out in the writ petition at all. Not a case made out. Therefore, kindly keep it in mind, and I definitely show to your lordship what the provisions are. Kindly come to page 157. Rule 8, procedure of selection. The selection committee shall make prima facie scrutiny of the duly filled application forms submitted by the candidates having qualification. 2. The selection committee shall call all qualified candidates as mentioned in sub-rule 1 for the viva voce or interview and aptitude test. The performance of the candidates who will be called for viva voce or interview and aptitude test will be assessed separately by the interview board formed for the specific purpose. 3. Academic qualifications, training, performance in the TET, extracurricular activities, and performance in viva voce or interview and aptitude test shall be computed in the manner as mentioned in table A below. Then, Milord, for each separate marks mentioned, Madhyamik 5 marks, higher secondary 10, training as specified by NCT 15, then teacher eligibility TET the 5, extracurricular 5, viva voce or interview 5, aptitude test 5, total is 50. Then note 1, the percentage of marks obtained by the candidate in the Madhyamik examination or its equivalent, excluding additional marks, if any, shall be reduced proportionately to marks obtained out of 5. Supposing, Milord, somebody gets 500 marks out of 500 aggregate, he gets 5. Somebody gets 400 out of 500 weightage. Now, Milord, note 2, the percentage of marks obtained by the candidates in the higher secondary Madhyamik examination or its equivalent, excluding additional marks, if any, shall be reduced proportionately to the marks out of 10. Same procedure. Then note 3, the percentage of marks obtained by the candidate in the relevant teacher training shall be reduced separately, proportionately. But same thing, proportionality rule is to be followed. Then note 5. Note 4. The percentage of marks obtained TET examination shall be reduced proportionately. Then 5. Marks out of maximum 5 shall be awarded to the candidates in the extracurricular activities on the following extracurricular activities. In case of candidates applying for the earmark post as mentioned in such and such, that these are para teachers, marks out of 5 shall be awarded on teaching experience. This is regarding, Milord, para teachers for whom there is no aptitude test. Then kindly turn over 158.
Yes.
Page 158, sub-rule 4. The marks of candidates applying for non-earmarked vacancies shall be allotted as follows.
That's all right.
This is the bulk of candidates, non-earmarked vacancies.
Now, where is the aptitude test?
Aptitude test, it is defined in Rule 2C. Now, aptitude test marks I have shown to your lordship. 5 marks.
That's
at,
right.
at page 157. At page 157, my lord, Roman, the last one in the table, Roman 7, aptitude test 5 marks. Just before that, now Roman 6, Viva question interview 5 marks.
Now tell us what is the material before the single bench, the middle material, or because of which single bench felt that 157, 158 was not followed. Show us the relevant material placed before the single bench. Where is that in your affidavit? It is recorded in the order.
Yes.
But we would like to see the pleaded material before the single bench, that why the single bench came to the conclusion 157, 158 were not followed.
157, 158.
মানে 157 মানে এইটা,
Oh,
158 মানে এইটা।
no, not followed, my lord. The only basis is
What is the material before the
material
single
is, my
bench?
lord, examination of 30 interviewers.
Show us that material. There must be something on oath, something on affidavit.
Nothing. As I said, my lord, a spiral booklet.
Where is that spiral booklet?
Spiral booklet আছে তোমার?
স্পাইরাল বুকলেটে ওটা অ্যাপটিটিউড টেস্টের কথা কোথাও বলা নেই,
সেখানেও নেই।
এটা কোড নিজে থেকে বলেছে। কোথায় অ্যাপটিটিউড টেস্টের কথা বলা হয়েছে? কোথাও বলা নেই।
Something has to be seen, read, and then we have to.
Paragraph 14 of the judgment, paragraph 14.
That's right. 14 is there.
That's
But
right.
where
Otherwise,
does-
no other basis.
The material your lordship will find from paragraph 9 of the
Yes, paragraph 9, I just.
See, certain
How were they placed before the single bench?
nothing. They were called in the witness box and Lord some evidence that is what is recorded. Please
That's
come
right.
to page 6.
Then how did the board, according to the board, what did the board say? How did it conduct the aptitude test?
My lord, the aptitude test is taken by the interviewers, my lord, how it was conducted by each of more than 100
So what have you
interviewers.
stated when you were asked that question by the single bench?
Nothing is questioned. I am told, my lord, nothing is questioned.
Where is the board's affidavit before the single bench? Board's affidavit, report, whatever. Where is that affidavit of the board?
Text বলেছে, কিন্তু ওটা রিট পিটিশনে অ্যাপটিটিউড টেস্টের কথা ছিলই না। আমি কি
My lord, the board's affidavit, the only opportunity we got was to deal with the allegations contained in the writ petition. Nothing beyond that.
Now, please come to page 191.
আর একটা এফিডেভিটে অ্যাপটিটিউড টেস্ট
191.
Yes. There is a reference to an exception to the report filed by the board. So there must be a report for that. There must be an exception. Where is the report of the board?
একটা এফিডেভিটে বলেছি অ্যাপটিটিউড টেস্ট নিয়েছি।
আমাদের রিপোর্ট কোথায়? 164.
এটা আমাদের অপোজিশন।
The board used
One at page 164.
Yes, 164.
board's affidavit, my lord, are at page, my lord, 265 and my lord, 273. First affidavit at page 265. That was affirmed, my lord, in terms of the order dated 17th of January 2023.
265.
265. My lord, this affidavit was affirmed in terms of the order, my lord, appearing at page 263.
We have seen that.
Kindly take paragraph 4 of this affidavit
266.
at page 266.
Yes.
There is a reference to the aptitude test. Both interview as also aptitude test.
Paragraph 5.
Then paragraph 6.
That is the 2022
Paragraph 5.
interview and aptitude test. That does not
16.
detain us here.
5 ষোলো নেই।
এটা
4 আর 5 ষোলো নেই। 4 আর 5 ষোলো নেই।
4 and 5, paragraph 4 and 5. This is dealing with 2016 recruitment process.
Very well. Please.
Then
Where did the honorable single bench get the material in the chart form, etc., that has been printed in the order? What is the basis of getting those materials?
My lord, that unaffirmed booklet.
Kindly come to page
Paragraph
11 and 12 of the order.
Page 292, my lord, paragraph 9.
Yes. Who prepared the 121-page booklet? You have a copy of the same.
That copy was supplied.
We cannot hear you.
On the next occasion, that copy was supplied to the board.
To the board. That was an unaffirmed booklet. What was, anyway, we'll come to you later. Yes.
Then, my lord, paragraph 9 at page 292, where, my lord, the
Yes.
But
let us assume, Mr. Gupta.
This is not that booklet.
Yes. Let us assume that this booklet, the marks that are reflected, taken notice of by the single bench are correct. 9.5, 10, 9.5 weightage. What has been the board stand regarding this before the single bench?
My lord, getting lesser marks in the academic examination does not always mean that the candidate will get lesser marks in the interview also.
Accepted.
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 But the court went by the fact, went by the assumption that how could a person who got lesser academic marks get higher marks in the interview? That's the only
No,
basis.
but that is, maybe there is a rider to that. That is acceptable. Your argument is acceptable. Academic marks, that would not.
Yes.
But then how could so many, according to the court, get 9.5, 10 serially in the interview? How did the board meet this?
There were thousands of candidates. Thousands of candidates. And definitely the same marks will be obtained by many of them. And many of them did well. They got
on the microphone.
Many of them did well, got more marks. Several thousand appointments are being made. 42,000. And out of them, somebody will be getting 9.5, somebody will be getting 10. Many of them will be getting. The Honorable Judge has pointed out only a few.
2.5
There are many.
Sir, 2.5 out of 3.
You have your records or you do not have your records? You do. You do not.
It was published with marks.
All.
District wise. No, as a whole published, but selection process district wise.
Publication was by the board in respect of the entire state. The recruitment was done at the DPSC level.
District wise.
Not really, district, DPSC.
Yes, please continue.
Now, I was making this submission. Was there any occasion for the court to make out a case for the petitioner, which they themselves did not make? That is why the Supreme Court says, I have brought one judgment, that it's not for the court to make out a case, a third case. Now, this is what, exactly what has been done by as appears from this judgment.
So what happens?
I have placed, the grounds on the prayers in the writ petition. How, if somebody sees these grounds and the prayers and then comes to the judgment, one will be astonished to find how these aspects are being gone into by the court. There is no amendment to the writ petition taking these grounds. And who says, at whose instance these interviewers are being questioned, being put to the box and questions are put to them by the court? At whose instance? Oh, I am told that one of the interviewers who during this examination by the court could not follow the question put to him in English.
Oh, that appeal came to us.
Oh, I think that I didn't know.
We reinstated his service.
I'm grateful.
It was the only reason he lost his job because he did not know English, and we found that he was a physical and works education teacher. So we asked for his reinstatement, but that was purely in the on the facts of that.
No,
case.
but here we are in the present facts of the case, in respect of the scope of challenge thrown, the relief claimed. How could this order be passed? And the paragraph 22 your lordship was referring to, there the court, what the court does is not a simple thing, my lord, that that you are not being put to the wolves. We are being put to the, because he's unsettling a settled thing. I have a regular job in I'm performing this regular job for last 6-7 years, and learned judge says you again go through this.
Go to the interview and the
Yes, again interview and aptitude test.
termination. Yes, we come to Mr. Bhattacharya. Let us everybody get an opportunity for today. We'll continue the matter tomorrow.
One more point I'll just indicate.
Please.
I have not cited a judgment on this. If I may give the judgment.
Time has not gone also. We are here for you even tomorrow. Yes.
But kindly give me my petition's copy. Scan 2 of 2023, 890. Scan 2 of 2023. But I just no. I tell you, Lord, sis, the point is, Lord, which was stopped initially was possibly initially, it just I assume that's was troubling to your Lord system. Kindly come to the advertisement first. Come to the page 230, the advertisement. That will make your lordships very clear of the situation. Can 2 of MAT 890 of 2023.
Yes.
Can 2. First, Miller, kindly see. Come, Miller, the qualification part 3, note 1. The person's qualified TET and having, Miller, got it, Miller? Page 230, advertisement, 230.
Yes.
Miller, kindly see, the person's qualified TET and having qualification of higher secondary pass under the West Bengal Council of Higher Secondary Education or its equivalents with at least 50% marks or graduates, irrespective of the marks obtained therein, without 2 years diploma education by whatever name in accordance with the National Council for Teacher Education Economics and so also will be eligible to apply for appointment of primary school teachers in the state, subject to condition that those who will be appointed without professional course shall acquire all this professional qualification within a period of 2 years from the year of appointment. It has been made clear in the advertisement itself. So for the non-trained is concerned, if you are non-trained, you have to obtain the qualification within a period of 2 years. Right, Millard? Now, Millard, kindly see here first. After the advertisement, I will show Millard what is I have not been made party in anywhere. Not a representative capacity, nothing. Justice Orijit Banerjee in his earlier judgment has held it. After 6 years, one cannot come. And without making them party, Justice Hiranmoy Bhattacharya on 23rd March this year has held it. No, it cannot be done. Same selection process. 2016 selection cannot be done. Now, I'm kindly say interview letter starts from page 231. Kindly see. Page 231.
Yes.
Your lordships will find numbers. I am just showing one as per example. See, this is the interview letter, W10, 19th October 2016.
Details of your venue for scrutiny verification and interview stock aptitude test to be conducted by the West Bengal Board of Primary Education is as mentioned below. Application roll number, email, mobile number, opted district Hooghly, venue name Hooghly District Primary School Council, Ranikul so date reporting 26 October 2016. I appeared in the interview. I am not concerned, Lord. I have appeared in the interview. After the interview has been done, my lord, the appointment letters were issued. Kindly come to page 52 to 58. Page 52 to 58. See. 11 February 2017.
Yes, that was a question. We are interrupting you. That was a question. We will come to Mr. Tiwari subsequently. As far as these candidate appointees, wait, this again, please remember, these are questions. Answers will be coming from you, and then these are the candidates who appeared. They had the qualification, they then got themselves training. Nothing backdoor about their walking into the jobs. Was there anything so backdoor about them to be faulted? They did what they were supposed to be told to be done. Now, if anything has happened after 7 years to the notice of the court, of course, you will explain. But what is backdoor about their entry into the service?
Kindly consider, my lord. This is a question of, my lord.
Have they opened a ventilator and walked into the room? Walked in the way they have been.
This is a question of meritorious untrained candidate and less meritorious.
Anyway, I think so. My lord, it is overall
meritorious and less meritorious.
This is the question.
This is the thing.
We know. This is the question we asked to you. The question is, there may be a main door to the room. They have been also opened a door, you walk in. They have not opened a ventilator or some side window and jumped into the room. It's not strictly that back door. So can they be put to task for something which maybe, arguably, the board has done or not done or undone? What is their level of complicity, if that may be the question? We'll come to you.
Yes, yes. But now similar, this appointment letter, kindly mark it, the letter. West Bengal Board of Primary Schools is appointed as on probation for 2 years. Right? Probation for 2 years. This is 11 February 2017. They did not come, including the probationary period. Take a case of a regular government employee's case. Our case is same. 11 February 2017. Now, my lord, kindly come to me, lord. I will just show to your lordships one document of the national central government, then your lordships will come. Kindly come to page 238. Because this document was not with them. Page 238. Kindly see 3rd August. Ministry of Human Resource Development. 3rd August 2017. This is regarding training of untrained in service elementary teachers in the government so aided private schools. It is apprised that the amendment to the section 23 subsection 2 of the RT Act to extend the period for such training to 31st March 2019 has been passed by the Parliament. Parliament has allowed it. Now, my lord, kindly come to there. Your lordships will come to page 241. Semester. First term. Second term. Second term. Expiring on 31st. Semester. Not the examination. Semester. Right? Now, my lord, kindly come to me, lord. Page 59. Right from page 59 to 72. All our successful certificate completed diploma in elementary service.
Now show us a document. You were called for the interview, or
well, I have shown to your lordships
for the interview and the aptitude.
No, that's one letter. 231. Kindly come to 231.
Please attend so and so interview.
Yes, yes. Details of a venue scrutiny so and so conducted by the West Bengal Board of Primary is mentioned below. Roll number so and so, venue name Hooghly District, venue address,
So this is the one single letter.
One, then 231, 232, single day, only one day. In respect of all the petitioners is there, I have given, I was reading just to save the time of your lordship's blood one.
Please, yes.
Just one, I was reading one document. But that's kind of details of your venue for scrutiny, stroke verification and interview, stroke aptitude test. But I will go, kindly appreciate this, Lord. I will go on the basis of their directions. I appeared in the interview and I have become successful. Appointment letters have been given. In the meantime, Lord, I have acquired the qualification which was required to be done in terms of the law. I have done it. I have shown your lordship the certificate. Now, my Lord, kindly come to page 220 to 229. This is, my Lord. See, the following, my Lord, the candidates, my Lord, I have given, my Lord, one example. I am not taking much time, my Lord. In every case, it is there. Have completed 2 years DLD course, 1 year period so and so, 6 months period so and so. Hence, the training benefit is thereby allowed in favor of them. My Lord, have dealt with so many education matters. Your lordships have seen that when the DLD course has been obtained, acquired, they are entitled to get the higher pay benefits, and this court in number of petitions have done it. And we have given it. They have paid it. Now, my Lord, kindly see, my Lord, confirmation, page 73 to 80. Kindly come back. Page 73 to 80. In consideration of rendering continuous and satisfactory service for 2 years since the date of appointment in the permanent post of primary stroke junior basic school teacher under the control of the Hooghly District Primary Council, the following priorities are hereby declared in terms of so and so, dated so and so, confirmed in their post with effect from the date mentioned against their names. So for the serial number 30, kindly see, one of the petitioners is there. Applicant is there, please to ask him.
Yes.
Therefore, appointment on probation, acquisition of DLD, having the benefit of the scale, then the confirmation. Full thing is completed. 2019, no. Kindly come to judgment, let's just see. Kindly come to Sulat. Page 250. See how many writ petitions have been moved. Page 250. This was the writ petition of 2017 even. Page 250. Can you mark it? Number of petitions, batch of petitions. 250.
Yes.
Kindly come to page 252. The petitioners have challenged the recruitment process conducted by the West Bengal Board of Primary Schools so and so pursuant to its notification 26th of 2000, inviting applications for filing the post of primary teachers in school. Therefore, challenge was there this selection process, this 2016 selection process. Kindly same selection process. Kindly come to Millard, page 254.
No, please read the line next after that, Mr. Bondapal.
My lord, which one, my lord?
In schools under different, therefore the cutoff mark, the challenge in the selection process was to let us
Same panel under the Empire General, it was submitted.
Has not followed the reservation policy.
No, I have did it. Just 1 minute. Yes, sir. Yes, one should investigate applied for filling out the post of primary under different district primary school council short run. Land Council for the petition submitted the while conducting selection. The board has not followed the reservation. The cut-off marks for getting employment selection category was much higher than so and so. Submitted those candidates in the reserve category who obtained higher marks. Then the cut-off marks so and so candidate and the general category should have been imposed so and so. Entire selection process was challenged on different grounds.
That is that.
Correct.
Then
Now, my lord, kindly come to page 254. Court's view. 254. Yes.
yes.
My lord, Rule 8, violation of Rule 8 was also challenged, my lord. That's in paragraph 3 in the judgment, 252. Now, my lord, kindly come to 254. The petitioners have challenged the process of selection and candidates for appointment to post of primary teachers in schools under different DPSs in the petitioners succeed in establishing that there was incurable infirmity in the recruitment process. The entire process along with the panel of successful candidates prepared pursuant to that will have to be set aside. I have given my answers consent to so and so on. I am unable to allow the dispute for reasons more than one. First, it is not any dispute that pursuant to the selection process that was initiated by issuance of notice so and so, a panel of successful candidates was prepared and appointed have been given to a huge number of candidates post of primary school teachers under different degree. If the petitioner's pair is allowed, the appointment of such candidates has to be set aside. In other words, such candidates will be badly affected if an order is passed as prayed for by the petitioner. This makes such candidates necessary parties to the instant writ application. Any persons who may be adversely affected by an order which may be passed in a legal proceeding is a necessary party to such proceeding. Without hearing, no effective order can be passed. An order passed without hearing, means it is a nullity. Is a nullity. Leave aside, Lord. What is the hard case and what is the soft case? Leave aside any factual things. Leave aside entire things. Is it a nullity? You have terminated my service. Is it a nullity? You are imposing a capital punishment, my lord, without having any trial.
Next.
Second, my lord, just can you see? Paragraph 20 is very important. Is the read rule permits? Is the read rules permits? Rule 12 under Rule 12 and Rule 53 to make it in a representative capacity? Not done.
Followed.
Remember where, my lord? Just one sentence. Since in the petition, our appointments have not been challenged or say sought for cancellation of the order of appointment, we are not interested at all.
Yes.
Therefore, necessary party is required. I have not been heard. My second point is this, my lord. Laws are well settled. I can, look, another judgment is there. I will not take much time. There's 23rd, so for this case, Vikas Bhattacharya appeared on behalf of the writ petitioners. 23rd March 2023, Justice Hiranmoy Bhattacharya has delivered a judgment, dismissed all the petitions. Point is, whether a single judge is bound by the judgment of the coordinate bench or not. If he disagrees with the judgment, our rule says he can refer the matter to the division bench. He cannot say, no, coordinate bench judgment is not applicable. The niceties of the laws will not be gone into. There are facts of the case. Therefore, if you lots of text it tomorrow also, I will show to you lots from Justice Krishna judgment. 1977, what the Justice Krishna has said, Justice Iyer has said, the judgment is not with me. There may be, if a law is well settled principles, court is bound to go in terms of the well settled principles of law, though court will not be persuaded. Expression is,
yes,
pressure of the lawyers. Expression was there, or any other factor. Loss is settled. Huh? And nobility in argument, right? My junior has reminded me.
And who can appreciate that part better than us just now?
That's right.
Yes.
Just a minute.
Yes. Now,
Done.
Mr. Kaur, a few sentences from you.
I have other points. Kindly take. They are very interesting, importantly.
Mr. Bhattacharya, we are not concluding.
I am giving understand your lordships will not conclude. One paragraph impression, if at all your lordship is carrying low marks, interview marks is there. Kindly come to this paragraph 20, page 43. kindly come, see. And compare with that paragraph of the judgment. See, my lord. See. Page 44, kindly come. This is our take 3.6. Madhyamik pass 4.062. You got it?
Yes.
HS 8.60. Therefore, on academical score, I have got it 15.722. Intake Viva 2.5, aptitude 2.5, total is 5. Mr. Gupta was telling 5 plus 5. Then out of 10, I have got 5. Am I a bad person? Am I? This is the academical qualifications given by the primary school board. But the learned judge has picked up few cases. See my chart, entire chart I have given. And last one has got total marks, my lord, page 7. This kindly see 20.815. 21.202. If this is having an educational qualifications, who can secure, my lord, 16 marks, is it an unreasonable?
Followed.
There was so much marking part is concerned, my lord, very interesting, just I will say, my lord. With great respect to the learned judge. Great respect, my lord. With great respect to any courts, any judges. Went on, he proceeded on that. Partho Chatterjee was arrested. Manik Bhattacharya was arrested. CBI is there. ED is there. Is it a relevant criteria for deciding the case? Is it? Is it? If that's so, how it is relevant? Therefore, the learned judge, my lord, with great respect to the learned judge, my lord, the judgment of the learned judge suffers from extraneous consideration, which are not relevant to the matters itself at all. Last one is a proposition of law. Other point judgment, proposition of law, just I touch it and I will give it. Let's take it.
Yes.
Let's take it, a CBI report is there. Let's take it. Any investigation report is against it.
Mr. Bhattacharya, we have one more day to go with.
Yes, let's take it. Just I'm giving.
So please,
let's take it. My lord, kindly appreciate.
There's a second.
In a report, even a report is filed under section 173, subsection 8 of the Code of Criminal Procedure, has no evidentiary value. It's an opinion. No report has been referred. Some CBI report, some ED's report. That will not. Anyway, tomorrow I will argue.
Yes, Mr. Kaur, a few quick, please on the mic.
Give a few points on which I wish to take up the argument in the appeal. The effect of the order puts us in a pre-employment stage. Now, the status as of today, we will be getting the salary of a para teacher. That is not what the judgment says. And for a period of 3 months, we will get the salary of a para teacher. Now, the fundamental principle, which is laid down by your lordships, the Supreme Court over and over again. And also, in a similar matter, which went up to the Supreme Court through our division bench, where the Supreme Court has laid down the law as to how you should deal with when a matter of pre-employment is involved, which might affect a large section of the public. This is one aspect which Mr. Bhattacharya has addressed to your lordship. I would like to supplement my argument. My second argument is that this impugned judgment was passed as a second thought by the learned judge, because in an earlier order passed on 3rd of April 2023, he had dismissed the petition on the ground of delay. Similar matters. Your lordships may kindly have a look at this, and your lordship can call for the records also. This is Lord 3rd of April 2023, where the court holds that petitioner has filed this application after participating in the interview process against State 2014, which was held in 2016. As the application has been filed after 7 years from the date of interview, I do not entertain this writ application and the same is dismissed. The identical facts. Here also, my Lord, writ petition filed after 7 years. Now, my Lord, I take the third point. That learned judge should have recused himself. Had got a take his people prior to the passing of the judgment. And Lord, I would rely on a judgment of the present Chief Justice dealing with a similar situation, where the court has held that the court, Lord, disentitles itself, disqualifies itself from the hearing the matter. The purpose of my petition, I don't want to, Lord, detain your Lordship.
Yes.
We have annexed evidence to that. We have annexed evidence. In my petition, I have annexed evidence.
What is your number? MAT?
MAT.
Next matter, item number 4.
Item number 4, MAT 874.
Achha, 4.
Lord, please come to advertisement.
Anyway, please place your points today. We will open them tomorrow.
Very well. Now, Lord, the other point is, Lord, entire impugned judgment is based on section 165 of the Evidence Act. Entire. Lord, these fact finding that the court did, court donned the hat of a prosecutor. And your Lordships have deprecated this in an earlier judgment, where this revision bench, Lord, I succeeded, Lord, on this point, that 165 can't be used by the court as a prosecutor. This is exactly what the court has done in this case. So, Lord, that is another point that I wish to take, that any material which is collected through, Lord, the process of 165.
Yes. Yes, we were.
I'll place, Lord, I'll place the judgment. I'm just giving your Lordships a broad outline. And Lord, on the hard facts, it can't be a harder than what it is on us today. The hard facts are that, Lord, after 7 years, the court has launched an inquiry or an investigation, dehorsed the pleading. Dehorsed the pleading of the parties. Because, Lord, what he has done, these are not materials, Lord, available. Your Lordship was asking that where is this material, where is that material. These are not materials which were on record. Because, Lord, we could have produced our record. If we were parties, we could have produced our records to show that we were called for the interview, we were given appointment letters, we were on probation, then we were confirmed. All these facts were with us. We were not made parties. And Lord, we were not even heard. So, Lord, these are the hard facts, that the hard facts were not there before the court. It couldn't have been before the court unless, Lord, we were made parties. Lord, if your Lordship reads the writ petition, I'll show it to your Lordship. The facts are admitted that they had full knowledge that the lists were published on particular dates. The dates are mentioned in the petition, in the pleadings. So, Lord, what were they doing? They were fence sitters. They were sitting on the fence. They were, these petitioners.
Expecting what?
Expecting that, they didn't expect anything because they reconciled to the fact that they were not selected. But, Lord, when all these orders are being passed by the court, they took a chance because they had full knowledge that the other courts have passed different orders. This learned judge himself had passed an order, which is not dismissing the matter after 7 years. And rightly so, because Lord, Limitation Act, although not doesn't apply, but Lord, this is a self-imposed discipline that the courts have.
That will be enough for today. We'll ask Mr. Tiwari for a few quick words. Yes.
Well, one thing will I just submit to your lordships.
Lord, the application for leave to appeal.
We'll deal with that. That will not be should not be a problem. Yes.
Blood 30 to 36,000 untrained candidates were terminated or dismissed from service. But there are thousands of people who are standing on the street. Well, a hard fact is this. And not only that, your lordship will not kindly appreciate one thing. Today, your lordship has to visualize the situation. Well, on a particular date, who were the more qualified or more meritorious candidate? These are the thing has to be looked into. And the board will not brought into existence when all these documents when? I'm asking the question to myself. On 28th of November 2022.
How? In what way?
Yes. Learned Judge will not directed the board will not to publish all these things in their website. Now board file an affidavit. In that affidavit, board has stated it was published on 28th of November 2022. After what I have submitted before the Learned Trial Judge, these are the documents of board. I have not, these are not my own documents. These documents were not downloaded from the board's website and I have submitted before the Learned Trial Judge. It has not come from alien. There is a board's document and the board's document will show they have appointed less meritorious candidates and better meritorious candidates are standing on the street.
No, but where is the affidavit of the board? We were asking.
Yes. This is the board. One page, kindly text one page 175 once.
Of where?
This is the Milord. Can filed in Milord 6873. 873 Milord can 1.
Yes, can 1 in 873.
873. Kindly text Milord page 164. Now, page 164, this is the affidavit in opposition of the board in terms of the order passed by the Learned Second Judge on 19th of April 2023. Now, your lordship kindly text one page. I will show to your lordship page 175. Paragraph 9, last 2 lines. Page 175, paragraph 9, paragraph 9, last 3 lines. May I place it? However, in terms of the direction passed by this court, by this honor court, the answering respondents on 28th of November 2022 did publish the breakup of marks of the candidates who were recommended from 2016 recruitment process. Now, this has come into the light on 28th of November 2022. Now, something has gotten in the state of board administration that has brought into existence on 28th of November 2022. So how my learned senior friend was referring to the judgment delivered by Justice Hon'ble Bhattacharya and Justice Arijit Banerjee. On these date, these facts were not there. These facts came into existence on 28/11/2022. And I can show to your lordship, the person, board is saying, I got 15 marks. Now, 13 marks. I am also untrained candidate. Mr. Bandyopadhyay client also untrained candidate. Now, I got 15. I did not get appointment, but he is having got lesser mark. He got appointment. That will be reflected from the boards. I shall show to your lordship on the next occasion how these less meritorious candidates were appointed. This is the extraneous consideration. He is saying that Learned Judge acted on extraneous consideration. I say, repeat, board has acted on extraneous consideration.
We asked you that question, that if the board has, as arguably, if the board has faulted itself in some way, how have these candidates, how can you say they have fraudulently acted, that after that they should be displaced from their position? How have they acted? They have done what they had to do. They had to get training, they got training. They were on probation.
If I would have been appointed, I could have get training by this time. Kindly visualize the system on.
Even
assuming for the moment, on a particular point of time, Both were equal. More, not only that, I was better meritorious than the candidates. But I could have been appointed. I could have get our training by this time.
True. But true. But as far as the interview aptitude test is concerned, it could have gone anyway for you and for any of them.
I will show to you, Lordship, there is no interview, no aptitude test. I'll demonstrate that. There is no aptitude test. Board could not satisfy the learned trial judge that there was an aptitude test. Board has pushing around the room. Board has said that sometimes somebody was the president. I have no knowledge. I came subsequently. President of the board will not affirm and every to that effect that though it is said that records will reveal that aptitude test was conducted, but nothing was produced before the learned trial judge. But there are documents when I can show to you, Lordship, that everything was false. The entire recruitment is a scam. I can show, I can demonstrate that.
We'll meet tomorrow at 3 o'clock.
Yes.
Ashun. Parties / are represented in the order of their names as written above. First title. Each of the learned senior counsel representing the appellants and the respondents. Tinte appeal আছে.
Your lordships are hearing all of us.
Yes.
That will be taking time. 3 p.m. maybe too late.
If possible, we will go into the evening.
Okay.
Beyond 4. If possible, you have to spare that time. Senior counsel. Submissions.
All the affected parties.
Let this appeal be treated as part of the. Let this appeal be treated as part of Let the matter next tomorrow fixed matter at
praying your lordship leave by law to move the can application for addition of party in this matter.
It should be made party because we are affected party.
Give the application.
Yes, madam.
2,600
appeal করতে বলছে addition of party না
Yes, we can application
for addition of party আছে.
Let additional applications pertaining to the issue be also placed. ওই application number গুলো দিয়ে
No, application additional party will problem হয়ে যায়.
You have to get
Cannot be added as a party respondents.
You have to get
Independent appeal. That independent appeal is all right.
Mr. Chatterjee, if you want to add yourself as a party, do whatever. Get the commissioner's affidavit mentioned with us. Don't get in line.
Only one thing, kindly see. Cannot be any additional party in this matter.
We
prefer and substantive appeal.
Yes, maybe whatever yes or no, go confirm an affidavit, write out a mention slip, we will look.
Substantive appeal.
This matter, Lordship, affidavit is done, Lordship.